may resume your examination.
Thank you. Sir, just to refresh your recollection, right before we broke for lunch, you testified under oath as follows. Question, by the way, Ms. Smith was not only your girlfriend, she was your patient. Was she not? Answer, absolutely not. Question, that's not true. Answer, no, it's not true. Question, did you ever diagnose her? Answer, no, I did not. Question, did you ever consult with her over the phone? Answer, no, I did not in a professional way. Question, well, what do you mean by that? Answer, I talked with her over the phone conversations, the same kind of conversation I'd have with a friend. Question, did you do telephone consultations where you would diagnose her? Answer, no, I didn't. Do you recall giving that testimony?
Yes, I do.
Right. And showing you exhibit, what has been marked as exhibit number 112. May I approach a witness?
Yes.
Thank you. Just a minute to read that to yourself.
Okay, I've read it.
Okay. Is that a typed letter dated September 3rd, 1989?
Yes, it is.
Is it addressed to whom it may concern?
Yes, it is.
Is it signed by J. Jerome Oziel, Ph.D., MFCC, Director, Beverly Psychiatric and Psychological Center, Associate Clinical Professor of Psychiatry, School of Medicine, University of Southern California?
Appears to be.
Is that your signature on the letter?
Looks like it.
Would you read to the jury what it says after to whom it may concern?
Yes. It says Judalon Smith was incapacitated 8/30/89 by a chronic stress-induced panic disorder as reported to me by her via telephone. This panic disorder manifests itself in this individual by periodic lateral anesthesia and paresthesias, numbness and tingling that render her seriously incapacitated in related to motor function. In particular, this condition would render her incapable of operating a motor vehicle and possibly of normal ambulation. Based on extensive phone consultation, I advised Ms. Smith not to attempt to leave her domicile and or drive until these symptoms were ameliorated or eliminated. This advice was predicated upon the conclusion that ambulation and or operation of a motor vehicle during this period could endanger Ms. Smith and or others.
And it's signed by you, correct?
Appears to be.
Well, do you have any doubt about that?
I don't remember the letter. So the signature looks like it's mine, but I don't recall the letter.
You think it might be a forgery?
Didn't say that. I said I don't recall the letter.
I'm asking you, you recognize your own signature, do you not?
It appears to be my signature.
So we'll take a look at it.
I did take a look at it.
And do you know your own signature?
Roughly, that looks like it resembles my signature.
Well, when you say resembles, is there a doubt in your mind based on you writing your own signature, whether that's your signature on that letter?
It looks like my signature. I don't recall the letter.
The question is that your signature based on your, let me back up. Do you know what your own signature looks like?
Objection asked and answered.
Answer the question.
Yes, this appears to be my signature.
And my question is, do you have some doubt about that?
No, I said it appears to be my signature.
Are you trying to convey to the juries that it may have been forged or it's not your signature?
I only said that I don't recall the letter. It looks like my signature.
And in the second paragraph of that letter, which you read rather quickly, it begins with a sentence, based on an extensive phone consultation, I advise Ms. Smith not to attempt to leave her domicile and or drive until these symptoms were ameliorated or eliminated. Do you see that sentence?
Yes, I do.
When was the extensive phone consultation that you conducted in reference to this letter?
Well, specifically, Ms. Smith called me and told me that she was having these symptoms, and she asked me to do her a favor. I'm assuming that that's what this letter relates to, and the favor had to do with her having a small claims court hearing where she felt that she wasn't feeling good and was having panic attack symptoms and so on and so forth, and said she was going to lose her case if in fact she didn't get some sort of an excuse or letter or something stating that she was in fact having anxiety attacks, so on and so forth. So she asked me to write a letter that she could use in small claims court that had to do with simply relating what she told me over the phone, putting it in writing so she could use it to try to get a small claims court extension so she wouldn't lose several $1,000s in rent she was due or something of that nature. And as a favor to her, in the capacity of the relationship we did have, which was friend, business person, a girlfriend, however you want to characterize it, apparently I wrote a letter as a result of a favor that she asked me to do, in the same way that maybe a next-door neighbor would ask the doctor who lives next to him, my kid was out of school yesterday with a cold, would you mind writing a letter for the school saying that my kid was out yesterday? And it was in the capacity of the exact relationship that I've described with Smith that I wrote this letter as a favor to her and upon her request.
So when you told the jury just before the lunch break, in answer to the question, did you do telephone consultations where you would diagnose her, and you gave your answer, no, I didn't, that was false testimony, was it not?
No, to the best of my knowledge and belief, it wasn't false testimony. First of all, there is no psychiatric diagnosis here, according to DSM-3 or period. There's a list of symptoms that she reported to me, and I think I said reported to me by telephone. And this was not a professional consultation. She was asking me to do her a favor in the context of a friend-girlfriend relationship.
When you testified under oath to this jury before the lunch hour in answer to the question, did you ever diagnose her? And your answer, no, I did not. That was false testimony, was it not?
If this is construed as a diagnosis, that would have been false testimony. If it's not construed as a diagnosis, it wouldn't be.
And the first sentence of that letter says, Judalon Smith was incapacitated 8/30/89 by a chronic stress-induced panic disorder, as reported to me by her via telephone. Is that a diagnosis?
She reported to me that that's what she had. If it was a diagnosis by me upon examination of her, I guess it would be, but it wasn't.
And you just testified, I think, that your understanding was that she was going to use this letter as part of a court case. Isn't that true?
As part of a small claims court case to explain why she hadn't been able to get in time for her to continue her case to get her money back from somebody who owed her some money.
So you knew that this letter was going to have some use in the court proceedings that she was involved in. Isn't that true?
Believe that that's how she was intending to use it.
And you wrote the letter in such a way to make the court or whoever was considering the letter think that you were diagnosing her. Isn't that true?
I wouldn't know what the court would think, but I wrote it to give her a reason, basically, based upon what she reported to me, why she was in fact not able to get to court so that she wouldn't needlessly lose several $1,000s as a favor to her.
Well, you signed it J.L. Jerome Oziel, Ph.D., MFCC, Director, Beverly Psychiatric and Psychological Center, Associate Clinical Professor of Psychiatry, School of Medicine, University of Southern California, didn't you?
I did.
And you also tried to create the impression with whoever was reading this letter that your diagnosis was based on an extensive phone consultation. Isn't that true?
I'd say that would be a reasonable assumption.
And did you think when you wrote this letter on September 3rd, 1989, that it was false? That is the information in here, as reported to you by Ms. Smith and as you diagnosed her, is that false information you were trying to provide to the court?
First of all, I didn't diagnose her. She stated to me that she had these symptoms, and I simply reiterated what she told me she had and simply signed it. And it was in the context of a long-standing personal and business relationship.
Question, doctor, is did you think the information in this letter was false when you wrote it?
No.
Were you trying to create the impression for the court, or whoever it was she was going to use this letter for, that you were the doctor and that this was your diagnosis, that is, that she suffered from chronic stress-induced panic disorder?
I think I was trying to create the impression that she couldn't come to the court in time for her to save her couple $1,000s, because that's what she actually was telling me on the phone and asking me to write the letter.
Well, you didn't sign this letter, L. Jerome Oziel, concerned citizen, did you?
I don't think that's what it says, no.
You didn't sign it, L. Jerome Oziel, boyfriend, did you?
No, it doesn't say that either.
You signed it in your official capacity as a psychotherapist, did you not?
I did sign it that way.
And I asked you again, sir, whether or not Miss Smith was your patient as well as your girlfriend around September 3rd, 1989.
She was not.
Did you believe on September 3rd, 1989 that she was suffering from chronic stress-induced panic disorder?
That's what she told me.
Did you believe, based on what she told you or otherwise, that she was suffering from chronic stress-induced panic disorder when you wrote this letter on September 3rd, 1989?
That's what she described. I didn't not believe it.
But you wrote in a letter signed by you that that was your diagnosis.
I was just reporting, no, I was reporting what she told me.
Doctor, do you have a term in psychology for someone who makes statements about somebody else but is really saying more about themselves than they are about the person they're describing?
No, I don't know of any phrase that describes that.
You've never heard of a phrase that describes someone who makes a statement about somebody that is more descriptive of the person making the phrase than it is the person being described?
No, I'm not aware of any such phrase.
Okay. And do you know what the term projection means?
Yes,
What is projection?
I'll let you define it.
Well, you tell me. It's a
Well,
psychological term, is it not?
It just has to do with basically imposing upon other people things that you're actually feeling.
Isn't it the tendency to ascribe to another person feelings and thoughts or attitudes present in oneself? Is that a good working definition of it?
That would be a definition.
All right. And do you remember at some point in time that you called a press conference to make certain statements about Judalon Smith?
Yes, that's true.
Were you under a court order to hold that press conference?
No, I wasn't.
Because you testified here on direct examination you were under court order, but you weren't under court order to hold a press conference, were you?
No, I certainly was under court order to appear in this court. In fact, I was an involuntary witness.
Right. But no one ordered you to hold press conferences, did they? I mean, ordered by a court.
I believe I testified, no, there was not a court order to hold a press conference.
And you held the press conference on September 13th, 1990.
I don't recall the date.
Would it refresh your recollection if I showed you the written documents that you and your lawyers handed out for that press conference?
If you'd like.
All right. Number 13 is a set of phone records. 113, excuse me.
All right, 113 are phone records, is that
Phone
right?
records for the number 818-906-8853.
All right.
Exhibit number 114 is another set of phone records for area code 818-907-5083. And exhibit number 115 is a packet of documents entitled Media Alert.
All right, 113, 114, 115.
Thank you. And again, may I approach your witness? Your
Yes.
Honor? Thank you. And the letter, I'm not sure if I stated this for the record, is 112.
Yes, we've already marked that 112. Yes.
Dr. Oziel, showing you this packet of documents, the first page of which says Media Alert. Do you see that?
Yes, I do.
And is that a packet of documents that you and your attorneys put together to distribute to media people at your press conference?
Appears to be.
And does it say that the purpose of the press conference is Dr. Jerome Oziel and Mrs. Laurel Oziel will respond to the allegations made by Judalon Smith?
That's what it says.
And it says your press conference is going to be held September 13th, 1990 at 11 o'clock in the morning at the Beverly Hilton Hotel.
That's what it says.
And then it's followed by a biography of you, correct?
That's correct.
Setting forth that you hold 4 specialist certifications in the areas of your expertise.
I don't know what it says. I haven't read the biography.
Well, take a look at the last line.
Okay. Okay, that's what it says.
And the whole page has to do with your, basically the same information that, or some of the information that was in your CV that Ms. Abramson questioned you about.
Yes, I don't know what the rest of it is. I didn't look at it, but I'm assuming that's so.
Fine.
Okay.
And followed by the bio is a statement of your lawyer dated September 13th, 1990.
That's correct.
This is a document that was handed out to the press, right?
That's correct.
And then followed by that is a statement to the media by L. Jerome, Oziel, PhD.
That's correct.
And the first sentence of it says, ladies,
Objection, hearsay.
suffered for a non-hearsay purpose, right?
Do you have that document there? Do you know what he's reading from?
Yes, I know what he's reading from.
All right, let me see what it is.
I'm just going to read the first sentence.
Oh, the first paragraph?
No, the first sentence. Right?
You say the first sentence, you're talking about the first sentence of the first paragraph?
Yes.
All right. There you go.
Okay.
All right, the objection's overruled.
You say in your statement to the press, ladies and gentlemen, I consider myself a private man, correct?
That's what it says.
And then you go on to make several statements about Judalon Smith, correct?
Correct.
One of the statements you make is Judalon Smith was
Objection,
never...
hearsay.
All right, can we have a foundation as to whether he's the author of this document?
Yes. Doctor, did you compose this document yourself?
No.
It's presented as the statement of L. Jerome Oziel, PhD, correct?
Correct.
Did you adopt the statement? In other words, was it written by someone else and you read it to make sure it contained your thoughts and then you presented it as your own statement?
It was basically prepared by, I think, attorneys and some other people who were advising me. I did read it over.
And did it, at the time it was presented, accurately reflect statements that you yourself wanted to convey to the media?
That's my recollection.
And is one of the statements you conveyed to the media that Judalon Smith was never my patient, I never provided her, nor did she ever request, either formally or informally, any psychotherapeutic services?
I certainly did.
Did you also say in reference to Judalon Smith that Judalon Smith relentlessly pursued a committed relationship with me, which I rejected, which I repeatedly rejected?
Yes, I did.
Did you also say that Smith had extreme and unreciprocated feelings and designs toward you?
Basically, that's what that says.
What it says is, over the entire course of my knowing Smith, she continually wrote me dozens of obsessive letters, which clearly expose the extreme and unreciprocated feelings and designs she has toward me.
That's correct.
And you also described her as having an unreciprocated fixation on you, correct?
That's correct.
Now, isn't it true that it was really the other way around? That is, that before this session on October 31st, where you've testified to what the Menendez brothers have said, that you were obsessed with her?
Absolutely not.
Isn't that what projection is? In other words, you're describing her as being fixated with you when in fact you're the one who was fixated?
No, you're using the term inappropriately, and you're also assuming or trying to imply that it applies. It doesn't apply at all. No, it's not the reverse. It's absolutely false.
Now, is it your testimony that prior to October 31st, 1989, that Smith was pursuing you?
Yes.
And is it also your testimony that you were basically trying to get away from her?
Yes, that's correct.
And is it true, showing you Exhibit 113, that these are your phone records from one of your phones at your home in Sherman Oaks?
Appears to be.
And those phone records, do they not show one of your phone numbers is 818-906-8853, and the first record is dated October 16th, 1989, and it goes all the way through February 16th, 1994, correct?
I don't know. You haven't shown it to me.
Let me show it.
Okay. Okay, that appears to be correct.
And it's showing you Exhibit 114 is this a set of phone records from your other phone at your home, which is area code 818-907-5083.
And it appears to be. Okay.
Right. And returning down to 113, you'll see in the phone records themselves, there are highlighted certain numbers. Do you see that? In
Correct.
yellow. And the numbers that are highlighted are area code 213-931-0069. And the second number that's highlighted is 213-655-3031. Do you see that?
Right.
And those are the numbers of Judith and Smith, isn't that true?
I don't recall, but they probably are.
And you'll notice that beginning in early September, actually mid-September, September 18th specifically, you or someone in your home is calling that number repeatedly, day in and day out. Isn't that true?
I don't know about day in and day out, but there are a lot of calls to that number.
Well, when I say day in and day out, I mean that on September 18th, you called her at 8:39 a.m. and talked to her for 42 minutes, right?
That's correct.
By the way, that would have been you making the calls, right?
I'm assuming so.
No reason your wife would have been calling your lover, correct?
I don't think so.
And the next call on that same day, September 18th, you called her, after you talked to her for 42 minutes, you called her at 9:25 a.m. and talked to her for 1 minute, correct?
Appears to be correct.
You called her at 11:01 a.m. and talked to her for 4 minutes, correct?
Appears to be correct.
You called her at 9:39 p.m. that night, talked to her for 41 minutes, correct?
That's correct.
You called her at 10:23, talked to her for 23 minutes, correct?
Appears to be correct.
10:51 p.m. on the same date, you called her, talked to her for 13 minutes,
That appears to be correct.
correct? And just on this one page, which deals with September 13th through the 29th, there are 19 calls made to her, correct?
Yeah, the vast majority of them were 1 minute, 2 minute, 4 minute, so on and so forth calls, but there are some longer calls on it. That's correct.
And on the next page, which covers the period from September 29th through October 16th, on one page, you have called her $35 times, correct?
I didn't add them up, but it looks like I've called her quite a few times on that page.
Yeah. The whole page is basically covered with her number, is it not?
Well, it's probably the only total number that I was calling for the most part, but yes, there are a number of calls.
And those calls varied from 1 minute up to, looks to be 20 or 30 minutes in length, correct?
I'm looking at the times. Where are they? Here? Yeah, I can't even read the numbers. Most of them look like they're single-digit numbers, like 3 minutes, 5 minutes, 3 minutes, 2 minutes, 1 minute, 2 minute, 3 minutes. There are most all of these calls are 2-minute calls.
All hours of the day and night.
I don't know if I characterize that, but most all of these calls, I actually only see 3 or 4 long calls in this whole period of time, which is basically a period of 3 weeks. Most all of them are 2 or 3 minute calls, 4 minute calls, 2 minute calls, 1 minute call, things like that, which basically is hello, goodbye.
And I see on, you say over a period of month, I see on September 30th, you called her at 3:52, 6:42, 8:49, 9:54, correct?
Looks like it.
And was that all hello and goodbye?
No, there were a lot of issues that we were dealing with. Many of them, there are all sorts of issues that we were dealing with at that time.
And that was you calling her, right?
That was me calling her.
And the next page, same thing, right? Page is covered with calls that you made to her from October 17th through October 24th, all from your own, different times of the day and night, all made to Miss Smith. Isn't that right?
Again, most all those calls are 1 minute calls. Some of them are longer, but 1, 1, 1, 1, 1, 1, 2, 1, 1, 1, 1.
Well, you skipped one there, 61.
No, there was a 1 hour call, but most of those calls were 1 minute calls.
And the one after the 61-minute call?
It was a 15-minute call.
And 20 minutes and 22 minutes?
Just to save time, there probably are 1, 2, 3, 4, 5, 6 calls that were of any length at all in that whole, all the numbers you just pointed out.
And that's all before October 31st, right?
Yes, that's before October 31st.
You'll see the next page goes from October 26th through the end, November 15th, and you have probably 25 or 30 more calls. Ms. Smith.
Again, very much varying in length, but yes, there are a number of calls to Ms. Smith.
And the same with 114 from your other phone number shows numerous calls, all hours of the day or night made to Ms. Smith, does it not?
Well, I wouldn't, the all hours of the day and night is yours, but basically, there are a number of calls to Ms. Smith. That's correct.
Just as an example, October 6th, you called her at 10:58 p.m., correct?
I don't know, you're holding it too far for me to see. Okay, you're talking about, okay, yes.
And you talked to her for 268 minutes, did you not?
That's what it appears like.
That wasn't just hello or goodbye, was it?
No, that probably wasn't hello or goodbye at all.
And on that same page, on one page going from October 2nd to October 11th, you called her. Calls range 10 minutes, 65 minutes, 23 minutes, 268 minutes, 49 minutes, 27 minutes, 15 minutes, 18 minutes, 17 minutes, 23 minutes, 56 minutes, 17 minutes, correct?
Yes, spread amongst, again, over that entire period of time, a lot of 1 minute, 1 minute, 1 minute calls.
So who's being obsessive here, Doctor?
Judalyn Smith.
And isn't it true that in these telephone conversations where you would call up, that she would sometimes not be there and not return your calls, and you would constantly call back and say things like, call me back right away, tell her she was crazy, and keep repeating the same message over and over again, and she would refuse to return your call. Isn't that true?
Objection calls for hearsay, calls for speculation, and is compound and complex.
Why don't you rephrase the question? Yes.
Weren't there days, Doctor, when you would call up Judalyn Smith and she would not be home and not be returning your calls, and you would keep calling back over and over again, leaving her messages to please get in contact with you?
No, I don't recall that, and the nature of the messages was not to please get in contact with me.
Right. Let me, if I could, have next more, Exhibit 115.
It'd be 116.
116, sorry.
Can we approach, please?
All right, before it's marked, you may approach. Before it's marked, you may approach.
Doctor, all those phone calls I read to you were made before October 31st, 1989, were they not?
Yes, they were.
And is it true that before October 31st, 1989, the weekend before that date, that you and Ms. Smith went to Arizona together,
I don't recall that.
flying under the name of Mr. and Mrs. Jerome Oziel?
I don't recall that.
And is it true that on the 28th, or between the 28th and the 30th of October, regardless of where you were, that you and Judalyn Smith got into a lover's quarrel over something having to do with jealousy?
I don't recall anything about that.
That may have happened, you just don't remember.
Your objectives are being irrelevant.
What was the date of the inquiry?
Between the weekend of October, or the days of October 28th to the 30th, 1989.
Overruled.
I don't recall that.
Have a one-page piece of paper to my next morning.
All right, that'll be 116.
Didn't we mark the tape on?
No.
Doctor, showing you what has been marked as 116. Do you recognize that as a receipt with your name on it and a boarding pass to an airplane?
Yes, appears to be.
And is the receipt to a place in Tempe, Arizona called West Court in the Buttes, B-U-T-T-E-S?
Yes, it is.
And is that in the name of Oziel / Judalon Mr.?
That's what it says, right?
And is there also a boarding pass?
There's a boarding pass.
Does that refresh your memory as to when you were in Arizona with Judalon Smith?
Yes, it appears to.
When is that?
No, I mean, I'm assuming that if that's the date that you got these from, I'm assuming that that's, I don't see anything that has a date on this, or does it? Is there a date on here somewhere?
Well, it may be a little faint, but my question is whether you can use that in any way to refresh your memory.
No, I don't remember when I was in Arizona. So if there's a date on here, that would refresh my memory.
In any event, do you remember just before you had these sessions on the 31st that you and Judalon Smith had an argument which resulted in her basically saying she didn't want anything to do with you anymore?
No,
You laugh at that, correct?
it's absolutely not true.
All right. Is that as absolutely not true as your statement before lunch that you absolutely did not diagnose her?
I think I-
Argumentative.
Objection sustained.
And it's your testimony then that there was no point in time right before the sessions with the Menendez brothers where you got into an argument with Judalon Smith. Is that true?
No, I didn't say that. Anybody can get into an argument at any point. I just don't recall specifically having had an argument at that time, and I definitely don't recall any argument such as you described.
Well, let me ask you a broader question. Was your relationship with Miss Smith troubled in any way just before these sessions with the Menendez brothers took place?
It certainly was.
And was one of the reasons why you were making all those telephone calls because of the trouble between the two of you?
One of the reasons I was making all of these telephone calls, or a lot of them, had to do with Judalon Smith obsessively calling me and wanting reassurance and trying to elicit me calling her. And in addition, she couldn't call me at my home, so she asked me to call her very frequently. So it was at her request that I made these phone calls.
Including the 268-minute one?
Absolutely. No different than the other one. She was requesting that I make those phone calls. So,
Go ahead.
no. So basically, this is a completely distorted record. The reason it's distorted is that it only involves, it doesn't acknowledge the fact that she was asking me and calling me and trying to find ways to get me to call her frequently, asking me to call her extremely frequently, and in addition to that, telling me that she couldn't call me where I was located because in the one instance I was in my office, in the second instance I was at my home.
Did she have some way to keep you on the phone for 268 minutes?
We talked. We had a relationship. We had a business relationship, a personal relationship, both. It started out as a business relationship, and I might add, a great many of these calls were business calls. They were not personal calls.
At 10:58 at night for 268 minutes was a business call?
May very well have been. We were planning multiple business projects.
And are you saying that all those phone calls, day in and day out, in the period before October 31st, were prompted by phone calls that she made to you, saying, please call me up, Dr. Oziel, or words to that effect?
I think that there's a tremendous amount of documentation that I have in writing that, yes, she was repeatedly requesting me to call her and asking me to be in contact with her very, very frequently.
And I
And
guess,
move to strike that answer for the part that's not responsive
All right,
and
the
hearsay.
objection is sustained, the entire answer is stricken.
I guess that'd show up in her phone records, wouldn't it?
All right, counsel, we don't have a question that relates to an answer, so you'll have to rephrase your question.
All right. Doctor, are you saying that she made phone calls to you that are, at least on the face of it, as obsessive appearing as your phone calls to her?
I didn't characterize these as obsessive at all. You did. And no, what she did is write me dozens and dozens of letters that contain that content and engage in extremely frequent conversations that were, insecurity-based and really asking me to frequently call her and be in contact with her, which is that and the business things we were working on account for the phone calls that I made and the fact that she couldn't call me.
And was that the only inducement she gave to you? In other words, she would give you letters saying, Jerry, please call me, and then that would produce all these telephone calls?
I didn't say that.
Well, was there something else she did that caused you to make those phone calls day after day,
She
hour
threatened-
after hour,
She threatened
minute
to
after
commit suicide.
minute?
There wasn't minute after minute.
Well, do you want to go through them again, Doctor?
Objection argumentative.
Objection sustained. Your question?
Was there some other device that she had for causing you to make all those telephone calls?
I think I already testified that we were involved in business discussions and a personal relationship, and she verbally requested me to call her extremely frequently. As a matter of fact, if I didn't call her, she became very insecure and, extremely unhappy.
Doctor, is it true that from the period between October 31st, 1989, and the time when the search warrant was served at your house, that you at one point suggested to Judalon Smith that she should call your wife and disguise her voice as Erik and tell your wife, "Hello, Laurel, this is Erik. You're in trouble. I'm going to kill you." Did you suggest that to, you laugh at that?
It's absurd. No, I did not.
Your Honor, at this time I have to take a break because I'm at the point where I need to
All right,
make
well-
an offer of proof.
Okay, we'll take a recess and we'll resume at 10 minutes to the hour. Ladies and gentlemen, don't discuss this case with anyone. Don't form any opinions about it. We'll resume at 10 minutes to the hour. And all people in the audience, please remain until the jurors have left the courtroom. And these were tapes that were provided to the defense by the prosecution.
Yes, Your Honor, in discovery.
What did you propose to do?
Your Honor, as to tape number 47, I'd like to play, I have the tape advanced to about midway. In the beginning of the tape are other phone messages incoming into Miss Smith's home from other people. About midway through the tape starts a series of calls from Dr. Oziel, pretty much one right after the other, and I have the tape set to begin when that call comes in.
Are these time coded in any way?
They're just, there's an indication of day and time, but not day. And it's my...
Day of the week and time?
Yes, correct.
Day?
It'll say Monday, 1 o'clock, but it doesn't say Monday, March 5th or whatever. And it's my offer of proof that these tape-recorded statements were made sometime between October 31st, 1989 and March 8th, 1990, when the search warrant was served on Dr. Oziel's residence. And there will be testimony to that effect from the scene.
Well, is it any more precise than that? Does it relate to the period in close proximity to October 31st or more in the area of March the 8th?
I think it's probably more in the area of March the 8th.
And you wanted to play that now?
Yes.
In court and just return?
And based on that statement, Your Honor, I think the context of this will be October 31st, but...
You better let me talk to your attorney. I swear you better let me talk to your attorney. What you're doing, or what you're thinking of doing, is absolute insanity. You've got to stop this. You've got to stop this. You literally need to talk to a psychotherapist, and you literally need to let me talk to your attorney. I've got to
Jerry,
get back.
nothing is wrong with me.
Julie,
I know the truth, and you placed my life in jeopardy by putting me in that office and putting me in
Julie,
that room and
you
letting
asked
those
me
boys
that
see
over and
and
over
see
and over
me.
again, and you're the one that duplicated the tapes. The bottom line is, look, let's stop this nonsense.
Because you made me fear for your life, that they were going to come into the office and kill you.
Julie, they might have. Get out of here. You were there.
I know, and so unfortunately now, I know because I overheard stuff and I saw them and I know, and you told me word for word everything that happened in those sessions.
You don't know a lot of things that happened, and a lot of what was told you wasn't even accurate.
Jerry, you were not lying. You gave the session word for word to me and to Laurel.
Julie,
All the sessions.
now,
You
however,
forget that.
Did you tape record the session last night, or was it?
So, Your Honor, I would seek to play the portion where it stops with, you don't know a lot of things that happened, and a lot of what was told you isn't even accurate. Just that portion.
All right, people wish to respond to that. If there's a foundation laid, as, of course, this would relate to any conversation that he spoke to her about.
Other than the clarification of what date that refers to.
Okay, all right, and you have a third tape?
Yes. The last tape is Exhibit 45 we would seek to play in its entirety. And we prepared
That's Exhibit 119, you mean?
119, yes, tape 45, excuse me. We prepared a transcript of this tape because it's very brief, and providing that to counsel. And in this tape, Your Honor, well, can I play it from the tape?
Yes, but let me say this, that if these tapes are indeed played for the jury, the defense will be required to provide redacted copies of the tape, which only includes those portions that are played for the jury, so that we don't have a situation that if these exhibits are received, that there is a tape that has a lot of material on it that has nothing to do with what was actually played for the jury.
And Your Honor, could I provide the court with a transcript of this and indicate to the court, the offer of proof is this. This is a very brief tape, and it's a tape where Smith and Oziel are talking basically about how to get rid of Smith's wife, Laurel Oziel. And Oziel says on the tape to Smith, I think you should call up and you should use one of your disguised voices and say, hello, Laurel, this is Erik. You're in trouble. I'm going to kill you.
Where's that in the transcript?
That is,
Page 2, middle of page 1.
page 2 minutes.
All right.
But the thing is, tomorrow is that the reason that half of the day is supposed to be screwed up tomorrow is that there's 2 weddings coming up with 2 patients that were treated for a combined term of 8 years. And we're subject by wedding presents
offer proof, I'd be glad to cut out Dr. Oziel's country and western singing. Really, the important point is the portion I isolated from the court. I'll be playing the rest of it just to give it context.
What is people's response to this tape being played?
Well, first of all, there's no indication that it was made with Dr. Oziel's consent, in which case, if it wasn't done at the request of the police, then it's a violation of the law, number one. Number two, we've never seen this transcript before. It appears to be inaccurate. Just from this one go-through, the transcript is not accurate. And in that, the defense has objected to our transcript and made us redo them. I think that we need some time to check the transcript. And I would like some opportunity to investigate this to make sure that this is accurate and that this is not made in violation of the law.
Judge, these tapes were given to us in discovery.
You know, just because we provide discovery doesn't mean all of it's coming in.
Well,
Right.
I note they didn't arrest the
Hold on,
witness
sorry.
and she turned it over to Bernardo. They seemed to be concerned with the legality when they thought it might be useful for their case. Now we're hearing for the first time this legality.
As to the problem with the transcript, it's provided merely as an aid, just as they provided transcripts as an aid. I think on the essential point of Oziel telling her to call up his wife and make like she's Erik, that the transcript does aid, and the tape is clear as to that portion. There are other portions which were inaudible, and I'm playing the first part before the statement that we're seeking to get to, merely to give it context. I'd be glad just to isolate that statement, and then we wouldn't need a transcript at all, but I think to give the jury the full flavor of the context of the statement, it's important to play the entire thing. It may be the transcript is not 100% accurate, but it's hard to get it 100% accurate, and I don't think it's inaudible in the crucial portion that we seek to admit.
Well, let me inquire, does anyone have any idea when this tape was made? Is there any offer of proof as to how you'll establish when it was made?
Well, I think,
Or the circumstances of its production?
well, the circumstances of its production, I believe, are,
Not how it came into your possession, but how it was initially produced, the tape itself.
well, the only thing I do know is that the Beverly Hills Police Department gave Judalon Smith a recording device and asked her to start recording her telephone calls, and I'm not sure whether this was one of those calls, but I believe it is. It was provided to us in discovery, and I think it may have been done at the request of the Beverly Hills Police Department with a recording device that was placed on Miss Smith's phone on or after March 5th, 1990, when
Well,
she...
this doesn't sound like a phone conversation. It sounds as though two people were speaking in the same room.
Well, she also wore some sort of a body device at the request of the police department on March 17th, but I think I can authenticate the date if that becomes important. It's really the fact the statement was made at all that we're trying to get to, but Dr. Oziel does refer to his tomorrow being screwed up because he has to go buy some wedding gifts or a Hanukkah gift, and I think I could establish through his own mouth when that was. But in any event, I think that the important point is that the statement was made, not when.
All right, let me ask of the prosecution, what is your understanding of how this tape was generated?
Detective Zoller indicated to me that Ms. Smith provided him with a number of tape recordings that she had of various conversations. Is that correct, Detective Zoller? It also appears from this particular transcript, I believe Hanukkah is usually in December. And she...
Christmas always is.
Okay, one person speak at a time. We don't need interruptions.
And so I have some suspicions that this tape was not made by the author with the authorization or in order to aid the investigation. She didn't meet up with Detective Zoller until March 5th of 1990. It's my understanding that Hanukkah or Christmas of 1990, they were no longer in contact, so this could only be in reference to Hanukkah or Christmas of 1989. And it appears then that this was made prior to her affiliation or association with the police. So if, in fact, this first paragraph dates this, then it probably was made without the consent of both parties, which means that it would be in violation of the penal code.
Could I respond to that point, Your Honor?
Yes.
If the people are are arguing that there's some exclusionary rule that they can invoke, the statutory exclusionary rule, based on a violation of the wiretap statutes, that's not a proper argument. In light of Prop 8, there is no statutory exclusionary rule that can be invoked by the prosecution, even assuming this was illegally obtained, which I don't think it was. But even if it was, that doesn't raise any issue as to its admissibility in evidence.
What was the basis of your argument? Would you expand on that just briefly?
Yes.
What, Proposition 115 or Proposition 8?
Well,
Is it-
did I say 115?
No,
You said it.
I didn't say 8.
I think Proposition 8 abrogated any state statutory rules of exclusion and provided that all relevant evidence will be admissible unless it's precluded by federal law.
Wasn't there some argument by the defense in relationship to a New Jersey phone call and tape recording of
Yes.
it? And what was the basis of that argument?
New Jersey law.
And how does that relate to admissibility of evidence in California?
Well, our argument to the court was based on the New Jersey wiretap statute and not on the California statute because it was conducted outside the jurisdiction.
But this trial being conducted in California would be governed by Proposition 8. So I was just curious as to how you relate the argument that you made regarding New Jersey wiretap law and your argument regarding the California right of privacy law.
Well, the New Jersey law was based on the New Jersey statute. As the court will recall that argument was based on the wording of the New Jersey statute and the fact that the conversation there was conducted in New Jersey. But I think that 115, or excuse me, Proposition 8 would govern a situation where all the telephone conversations occurred inside of California.
Well, Proposition 8 governs the conduct of trials, not wiretapping or anything else. So it relates to admissibility of evidence in a courtroom. I'm just curious as to how you can have both arguments.
I understand, as I recall, the court did not exclude that tape
That's true. I just
based on that
it
argument.
was
Although,
intellectual curiosity as to
Yes.
how you could make this argument now when you made another argument before.
well, my only refuge is in New Jersey,
Okay.
and so that's the basis for the argument.
All right. Okay. Did the prosecution want to have a moment to research this subject?
Yes, Your Honor. I'm looking under the wiretap statute.
Well, regardless of that, my view is that at this point you've asked the witness whether he made this statement, so whether the tape is played now or at a later time, you've laid the foundation for it being played if it's admissible. Have you not?
Yes,
Okay, so...
but I also need to ask the witness certain questions about the context of this discussion. In other words, when he is referring to, well, she's waiting for the 8 months to go by, there is clarification that we need from the witness as to what's being referred to there. And basically, he had promised to dump his wife within an 8-month period of time, and so this whole discussion relates to Smith asking him when he's going to come through on his promise. And in response, Oziel saying, why don't you call her up and say you're Erik and threaten to kill her. So it's not something I can put in collaterally, and I do think at this point I need to use this tape to effectively impeach him, since he has been so emphatic and actually laughed in my face when I suggested that he made this statement. So if I don't pursue it at this point, the jury, I think, will be left with the inference that we have no ammunition to back up what, at least on the face of it, looks like a fairly outrageous charge.
Well, that aspect of it is not overly compelling. You asked a question, he denied it, and if you later prove it up, you prove it up. Whether it's done now or later doesn't add or detract from the evidence being before the jury. Yes?
Ms. Smith could testify that he made that statement to her, but under Penal Code Section 632D, it indicates that except as proof in an action of prosecution for violation of this section, No evidence obtained as a result of eavesdropping upon or recording a confidential communication in violation of this section shall be admissible in any judicial, administrative, legislative, or other proceeding. So it appears to me that that is parallel to the New Jersey law.
Well, there's also an exception in the wiretap statute for someone who solicits the commission of a crime, that's permissible to tape record under those circumstances. And it's our position that that exception would apply here if Dr. Oziel is telling his lover to call his wife and threaten to kill her.
Well, it sounded, from the nature of the conversation, that there was a lot of laughing going on at the time, and it wasn't a serious discussion, quite frankly, from the way the tape sounds.
I think that goes to the weight of it, and perhaps he can explain it away and say we were just kidding, but I think that's for the jury.
All right. The court's ruling in regards to the New Jersey tape recording was never made because the prosecution was able to introduce direct evidence from the witness regarding his recollection of that conversation, and therefore the court never was called upon to make a ruling in relation to whether the tape itself was received in evidence. And so that issue was never resolved one way or the other. I was just referring to your argument prior to that issue being resolved as it was. And there is an argument being made here. It hasn't been one that I've researched, and I'm sure counsel really hasn't either in the context of Proposition 8 as it relates to that particular code section. And I'm going to sustain the objection at this time with leave to reopen and pursue the matter when a foundation is laid by Ms. Smith, if she does testify, and when counsel have a chance to review the transcript and its accuracy, as well as the legal ramifications of tape recording surreptitiously made, not at the request of the police, which potentially could be in violation of the penal code law that deals with such tape recordings. And therefore, at this point, without prejudice to the defense bringing it up later in the trial, the court is going to sustain the objection.
Your Honor, I would request that before anybody elicit from Dr. Oziel this new piece of information concerning his now suddenly recovered memory that Ms. Smith was there on November 2nd, I'd like an in-camera hearing. He never testified to that in front of Judge Albrecht. He's never said that in 4 years. And so before it's elicited before the jury, I'd like an opportunity to question him on how come this memory suddenly came flashing back over the weekend.
I'm going to deny that request. That's something that could be done during cross-examination.
I'd also like some written form of discovery of the statements or whatever interview elicited that statement, since the first we heard of it was the first report heard of it this afternoon.
Yes, if there is any written documentation of it, you should provide it to the defense, as well as make such disclosures prior to the issue just arising during the questioning of a witness, if you're aware of it prior to that time. That applies to both sides. All right, we'll be in recess, and we'll resume in 10 minutes, 25 minutes after the hour.
Your Honor, there is a case that Mr. Soriano cited, it's People versus Otto, OTTO, which I think deals with these particular wiretap statutes.
Again, if either side wants to pursue it, you could file a short brief on the subject. The jurors are not present, and the parties are otherwise present, and want to discuss something.
Yes, Your Honor, I just wanted to clarify one aspect of the court's ruling, which is I intended, since the court will not allow me to play the tape, to lay a more adequate foundation through the witness's testimony based on his personal recollection of this particular conversation. And I wanted to make sure that didn't contravene the court's ruling, since I understand the court to be saying the tape itself at this point would not be admissible absent further foundation, but it's our position that certainly his recollection of that conversation would be admissible. So I wanted to let the court know that I did intend, with the court's permission of course, to ask him certain foundational questions as to this particular conversation.
Such as what?
Well, I wanted to ask him whether he recalled the conversation with Smith in which the two of them were discussing when it was that they were going to get rid of Oziel's wife, and whether in the course of that conversation he remembered stating to Smith that she ought to call up and disguise her voice as Eric's and say, "I'm going to kill you," or words to that effect.
Well, hasn't he already answered that he doesn't recall that conversation?
Well, I wish to lay a more adequate foundation, which I hope will refresh his memory, that this conversation in fact did take place.
Well, your inquiry is based on this tape, and there is a dispute as to whether or not the tape can be used for any purpose at this point. The
Well, I'm sorry.
concern I have is that, in essence, what you're doing is asking him questions, attempting to introduce the content of the tape, even though the tape itself isn't played, and he has no recollection of the conversation.
Well, I asked him the broad question whether he ever made that statement. My belief is that if I'm more specific as to the context of this conversation, he will recall it. And if he does recall it, based on his independent recollection, in terms of admissibility, he's testifying to his own recollection of a conversation. And he may very well, based on jogging his memory of asking whether he remembers stating certain things, say that I remember that conversation, and here's what my memory of that conversation was.
What is the people's response?
Well, we'd have objected that. I think they're trying to get in through the back door what they couldn't get in through the front door. And we've already stated our objections that we don't agree with how it was, how the tape was made. We don't agree with this transcript. And if counsel can't even lay the foundation for when the tape was made, then how is he going to give this information to the witness from the stand and to nail it down as to when this statement was supposedly made? So we would object.
Well, I can't lay the foundation unless I can ask the questions, and I think I can use anything to refresh the witness's recollection, including asking him whether he remembers making specific statements. There's several specific statements in this conversation that he may very well recall. And I haven't done that up to this point. I asked him the question, the important question, on the assumption that the tape could be used. If the tape cannot be used, I need to lay a more adequate foundation to indicate that he does or does not have independent recollection of this conversation.
Well, what I'll permit you to do is show him outside the jury's presence the transcript and see if that refreshes his recollection.
Fine.
And if it doesn't, then that will be the end of the examination. At this point, then the foundation will have to be laid. If this tape and its transcript are admissible, the foundation would have to be laid by Ms. Smith.
Could I have 1 minute to go out and do that?
Yes, I don't know if he is, the clerk indicated he wanted to make a phone call. I don't know if he has done that or not. If he's in the hallway, certainly you can show it to him. While we're waiting for Mr. Burt, one of the jurors has requested that on 2 days next week that we commence a little later in the morning. August the 12th, the request is that we begin approximately 10 a.m. and on August the 16th, we begin approximately 9:30 a.m. So I'll indicate to her that we will honor that request.
Your Honor, as long as we're waiting.
Yes.
We have a witness tomorrow morning, Dr. Lulo, that we want to put on. He's also a psychologist. And he's canceled appointments in the morning. Mr. Burt said he had no objection to us putting him on out of order. I wonder if the team for Erik Menendez has any objection to us putting him on. If in fact we're still in the midst of Dr. Oziel, we'd like to just put him on and let him go home by noon.
I have no objection.
Okay.
Unless you didn't discuss.
All right, then we will do that.
Thank you.
Could we have someone go out and see if Mr. Burt is actually in contact with the witness?
I'll volunteer.
The bailiff has gone out.
Oh.
any discussions?
Mr. Bird's not in the hallway. Dr. Oziel's there.
All right,
Dr. Oziel's
let's,
sitting right outside the door.
okay, let's have the witness in, so, and then we can have someone wait out there for Mr. Burt to return.
Now Mr. Bird's there. He said 1 second.
Okay, thank you. All right, are you ready to proceed, Mr. Burt?
Yes, and just to indicate to the court, Dr. Oziel indicated that it might have been a script that someone wrote, and he has no independent recollection of having said the words on the transcript, so we're going to have to do it over tape
I think,
at some point.
why can't we just, Your Honor, if I might, play the tape right now for Dr. Oziel, let him hear his own voice?
All right, counsel, you could, if you care to do that, and if it's otherwise admissible, you could do that at some other time, but this is the fourth day of this witness's examination. It's dragging on, and I propose that we wrap it up. So we'll continue in the order in which I direct that you continue the examination, which will be as we've outlined at the end of the last recess. All right, otherwise, we ready to proceed with the juries?
Yes.
Let's get the juries on this. All right, let's resume with the trial. Both jury panels are present, and Dr. Oziel, would you get back on the witness stand, please? Mr. Burt?
Thank you. Sir, just to back up for a minute, you stated that all those phone calls that are indicated in the records that were shown to you were made because Judalon Smith kept pressing you to make them. Is that a fair summary of what you were trying to say before?
No, I didn't say that all the calls were made because she was pressing me to make them. I said that in general, we had, there was an agreement that she couldn't call me at work. It was not possible because I had an answering service. There was no way to reach me, and she also couldn't call me at home because I was at home with my family. So she implored me to call her very frequently, verbally, each time I saw her, and also in writing. And for that reason, you would note that the calls emanated from my number to her number. A good portion of them were business calls. We had a number of business projects we were working on. Some of them were personal calls, and then a very large percentage of them were brief calls, 1 minute, 2 minutes, leaving a message on her answer machine or something of that nature.
And those telephone calls, those brief calls, were basically one of the situations where those calls were made was she ignoring you and you relentlessly pursuing her. Isn't that true?
No.
Calls for a conclusion and a guess on the part of the witness.
Overruled.
In other words, you said in your...
Wait, we haven't had an answer to that.
I'm sorry.
No, that's not correct.
You said in your press release that you gave to the media that Judalon Smith relentlessly pursued a committed relationship with me, correct?
That's correct.
And you said she had an unreciprocated fixation on you, correct?
That's correct.
And I asked you before the break whether or not it was just the opposite, correct?
That's correct. And I said no.
And isn't it true that you were the one that kept calling her up and having her call you, asking her to call you back at your office? You said she couldn't call you at your office, right?
Yes, she couldn't call me at my office, and she also couldn't call me at home. So she basically couldn't call me at all. So therefore, if she needed to talk with me, she had to call me back. But it wasn't because I was pursuing her. It's because that's the only way she could be in any contact with me.
And I want to play you Exhibit 118. You can just take 47.
Tape 47 is Exhibit 117.
This is take 40. 47, 117, Your Honor?
Yes.
Thank you. If you could just listen to this, Doctor, a portion of it.
Just calling to find out if you're okay. I called Donna to find out if you were okay, and she said that, I didn't ask if you were okay, I just asked if she heard from you, and she said that she hadn't heard from you at all. She was surprised and a little concerned. So I just wanted to make sure you're all right. Take care. Bye-bye. Tuesday, 6:57 p.m. Tuesday, 7:01 p.m. Tuesday, 7:51 p.m. All right. I just got through talking with, let's see, your upstairs landlord after Michael, after seeing your car with your stuff still under it from a few days ago. I was concerned about your well-being for reasons that you know about. And Donna said she hadn't heard from you for a couple of days, so I was concerned about you. So I stopped by, and I got the feeling that you had told Michael and perhaps your next-door neighbor, Robert, or whomever, who was there but didn't answer the door, not to be talking with me, that you didn't want me to know where you were or something. If that's the case, why don't you just let me know? Because I was really just concerned for you and trying to help you and trying to make sure that you're okay. And, that was the only point of my calling, and I've been concerned about you for 2 days because I'm real worried about you knowing what's happened in the past and how depressed you've gotten. So, just let me know if, in fact, for some reason you decide not to, or that you don't want to speak or have contact, if that's better for you, then just let me know. It'd be a lot easier and more reasonable, since I really just was real concerned about your welfare. I'm assuming that you're okay, since Michael wasn't concerned at all about checking your apartment and was very resistant to it, and said that he was sure that you probably really weren't there, but he couldn't tell for sure. So if you are there, why don't you give me a call and just let me know that everything is fine, and then that'll be that. That'll be fine. If you want to talk, you can let me know. Take care. Sure, pick up the phone. Are you there? Or weren't you really there? Are you really not at home? July. Tuesday, 11:33 p.m. Hello? If you're there and at home, and if I can believe anything you said about being home, please pick up the phone now. If you're home, July, please pick up the phone. I didn't think you were home. In fact, I was sure you were home. Tuesday, 11:34 p.m. I'm going to assume you were talking in front of somebody else and not at home. Absolutely, if you don't pick up the phone now. I guess you weren't home for you, Julan. There's another lie. You're dangerous. Alright. Tuesday, 11:35 p.m. Yes, Miss Smith, this is Lieutenant Griffey of the Police Department.
Was that your voice on that tape, Doctor?
Certainly was.
And that is you making a number of calls to Ms. Smith, is that correct?
No, that's correct, but the connotation about what it relates to is completely distorted.
Now, Doctor, I think you said at your press conference that Smith was never asked to eavesdrop on any of your patients in therapy, nor do I believe she ever did. Do you remember making that statement?
Yes.
And is that statement false?
No, that's not false.
Did she, to your knowledge, eavesdrop on your patient sessions?
I don't know if she eavesdropped. I know that I never asked her to eavesdrop, and she was in the office at some occasions. She could have eavesdropped, but I definitely didn't ask her to, and don't believe she did.
Well, did she ask you over and over again to be in the office at the time that you were having sessions with the Menendez brothers?
Yes. I wouldn't say over and over again, but she did on several occasions.
And did you say, okay, you should be there and invite her in to be at the sessions?
No, I said the opposite.
That she shouldn't be there?
That's correct.
So to your knowledge, she was not present at the October 31st, 1989 session, correct?
That's correct.
And according to your testimony here under oath, she wasn't present for the November 2nd, 1989 conversation either, was she?
I don't believe I testified to that under oath.
Well, I'm asking.
Well, I think she was there, November 2nd, 1989. Absolutely.
Where was she?
I think that she was in the waiting room at some point.
And was she there pursuant to an invitation that you made, or that she had asked you over and over again to be there on November 2nd?
No, she was there pursuant to her own insistence on coming when I told her not to come.
And was she in a position where she could overhear?
Again, I'm doubtful that she could have overheard anything at all from the waiting room. I don't believe it's physically possible, but if there was any physical possibility that one could overhear something from the waiting room, then it's theoretically possible. I don't believe it.
Well, do you remember having an argument with her where you were saying, come on, Judalon, you were there. You know what happened. Do you remember saying that to her?
No, but if I said that, it wouldn't probably be referring to what you're referring to now.
All right, let me, if I could. This is page 46.
118.
118.
For 25 hours about this, for over months, to attorneys. Every single one of them, when they understood the circumstances, said,
Excuse me, Your Honor,
if there's
I
any
believe this is not what was
The movies. And you know how when you sit in the movies, you always get... If you're not trying to threaten me and scare me, then why are you...
No, if you can't
What
find
they're
it,
going to
we'll
do
stop
is to
here.
turn them in. I guarantee.
You know, I mean,
Mr. Burt,
All right.
if you don't have the cue to the right spot, we'll just have to go on something else.
Now, Dr. Oziel, at some point since you last testified here, someone played you that tape, which I was just about to play for you, did they not?
No.
Did someone play a tape for you during these court proceedings outside the court that indicated that you admitted that Judalon Smith was present at one of these sessions?
Absolutely not.
And is it true that today on the witness stand is the first time you have ever testified that she was present in the waiting room on November 2nd?
No, it isn't.
Where have you ever made that statement before?
Well, for one, Ms. Abramson was present at a meeting, I believe, with Mr. Chaliff and with...
At this point, I would object without some kind of showing.
All right, let's have the question read back first. Objection is sustained, the answer is stricken. Let's have the question read back.
Question, and is it true that today on the witness stand is the first time you have ever testified that she was present in the waiting room on November 2nd?
Okay, the question has to do with whether you've ever testified, which refers, I assume, Mr. Burt, to a court proceeding. Is that correct?
Yes.
All right.
Your Honor, there was a question after that, actually.
That was the question that the witness was answering.
I don't recall whether I did or didn't testify or whether I was ever asked that question before.
Doctor, returning just for a moment to the sessions themselves on October 31st and November 2nd, I think you testified one session was about 4 hours, and the second session, I don't think you told us how long that was on November 2nd.
I believe it was approximately 3.5 hours.
And is it true that a lot of those two sessions was you talking?
I would say some portion of those two sessions was me talking. I don't know how much of it.
Is it true that your general habit and custom in sessions with your patients is to be rather long-winded and to make long declarative statements telling the patient, or as you call them, the client, how the patient or client feels?
No, I don't think that that's my tendency.
All right. Do you remember testifying in front of Judge Albrecht on June 15th, 1992? This is at page 1990, excuse me, at page 49.
Page 49?
49, yes. Remember making this statement, Doctor. Quote, "It is not uncommon for me to be long-winded, as probably people here can testify. And I do with patients sometimes go into long declarative sentences, even compound, that are very difficult to understand."
Excuse me, Your Honor. Is that page 49 of June 15th?
Yeah.
I gave that to you. Excuse me, may I approach the prosecution for a moment?
So why don't you approach the bench for a moment? All right, the court sustains an objection to the last question as it was being phrased. You may rephrase the question.
And Doctor, is it true that your pattern, practice, habit, and custom, whatever you want to call it, is sometimes in sessions to make statements to your patients for the purpose of eliciting their feelings? In other words, you'll make a statement that will prompt the patient to maybe express his feelings.
Definitely.
And was that process taking place during the October 31st and November 2nd sessions?
I don't know that that was taking place very much in the October 31st session, if at all. It probably was taking place sometime in the November 2nd session, because that's the essence of all counseling or therapy.
And what I'm trying to get at is these two sessions were not one-sided conversations between the brothers or them just talking to you. You were also part of this process.
Absolutely, I was
Would that
talking
be fair
them.
to say?
Yes, that would be fair.
All right. Now, I think we have the tape ready. And I think I was asking you whether you had ever had an argument with Smith where you would acknowledge that she was present at these sessions, overhearing the content of the sessions.
These sessions, meaning,
October 31st and November 2nd.
I don't know. Well, first of all, I don't think I would have been having an argument with her over, or having overheard anything the October 31st session, because I don't believe that she was there. But I could have had an argument that contained something about the November 2nd session. I don't recall. I mean, it was about 4 years ago.
As I understood what you were saying, it was that if she was there, at least your understanding was that she would not have heard any content of the conversation, correct?
The best of my belief, she would not have. I don't see how she could have.
So you, based on that, your own understanding of that, would not have been having an argument with her where you're telling her, Julian, you're there, you heard what happened, words to that effect.
I don't know whether I would have said that or wouldn't have said it, but I don't believe she could have overheard the sessions from the waiting room.
Let me play you a portion of the tape and ask you if this is your voice.
me. I know the truth, and you placed my life in jeopardy by putting me in that office and putting me in that room and letting those boys see
over and over and over
me.
again, and you're the one that duplicated the tapes. The bottom line is, look, let's stop this nonsense.
Because you made me fear for your life, that they were going to come into the office and kill you.
Julian, they might have. Get out of here, you were there.
I know, and so unfortunately now...
So is that your voice on that tape saying, get out of here, you were there?
Yes, but it didn't relate to what you're inferring it relates to at all. Not one bit.
I don't believe there was a question pending. I moved to strike that.
I believe he had just completed his answer. Objection overruled.
Be pleased to know we're almost done.
Excuse me?
I said you'll be pleased to know we're almost done, Doctor. Doctor, when you were testifying on direct examination on August 4th, 1993, you were asked about a portion of the conversation you had with the brothers on November 2nd, page 9399, lines 2 through 11. And specifically, this was in reference to whether they told you they did it for the money or not. And you were asked the question, what were the elements of the discussion? And you answered, they were concluding that they really didn't kill their parents for money, but out of hatred that they had, in particular toward their father, and to be free from all of the abusive and onerous characteristics that the father had, dominating them, having them feel inadequate, inferior, extracting impossible standards, controlling their life, so on and so forth. What was the so on and so forth?
I'm sorry, that was such a lengthy question. I don't remember it. Could you please rephrase or restate the question?
Sure. Your answer was...
Why don't you read the question so he understands what the
question is? And again, the context of this is the discussion about whether they did it for the money. And the question was, what were the elements of the discussion? And you answered, they really didn't kill their parents for money, but out of the hatred that they had, in particular toward their father, and to be free from all of the abusive and onerous characteristics that the father had, dominating them, having them feel inadequate, inferior, exacting impossible standards, controlling their life, so on and so forth. And my question is, what was the so on and so forth you were referring to there?
I don't know that I was referring to anything specific, but that did sound like a long declarative sentence.
It did?
Yes.
Okay. And the so on and so forth was to indicate that they made other statements along those same lines, but you simply didn't include those in your notes or didn't have recollection when you were answering that question.
I was just meaning to refer to the fact that they made a lot of different statements, some of which I enumerated specifically, that all related to similar concepts about why the murder was committed.
Now, it's also true that you told them if you were threatened, that there was no confidentiality. According to your testimony, they went ahead and threatened you, right?
No. My testimony was that Lyle, after that point, threatened me, not that they threatened me.
All right. And it was your testimony that you also told them that there was no confidentiality under those circumstances, correct?
I told them, right, that there would be no confidentiality under those circumstances.
And it's your testimony that Lyle nevertheless went ahead and made the damaging statements that you attribute to him, correct?
That's correct.
And I think you also testified that at the end of that November 2nd session, you were in great fear for your life, correct?
That's correct.
And is it true that at the end of that November 2nd session that you wrapped up the session by recommending to Lyle that he needed to establish a long-term relationship with you somehow?
Best of my recollection.
And did you have in mind that that long-term relationship was going to be a therapeutic one?
Yes.
Did you have in mind that that long-term relationship was one where you were going to get paid for seeing him?
If it was a therapeutic relationship, it would involve payment.
And did it also cross your mind that if you continued that relationship, that it would inure to your benefit financially?
No, I didn't.
Were you having some financial problems around the time of these sessions?
No, I wasn't.
Hadn't you just lost a lot of money, $1 million or in excess of that around October, November 1989?
I don't recall how much money I lost, but however much money I lost didn't put me in financial difficulty.
And when you told the brothers that you could be of some potential use to them in the event their case came to trial, did you have in mind that that was going to involve some number of hours you were going to be working on the case?
No, I wasn't thinking particularly about that at all.
Did you have in mind that you were going to advise them on how to deal with the estate that they were about to inherit?
No, I was requested that I advise them or help them find advisors, if you will, about the estate. That was a request made of me, that I find them independent people or help them find independent people to advise them.
Was your habit and custom at that time, that is October, November 1989, to establish a therapeutic relationship with a patient and then insinuate yourself into their business affairs and establish a dependent relationship where you would be in control of their affairs, financial affairs?
Well, no, not only was that not my habit, but that is not what occurred at all.
And you hadn't done that previously with a number of patients?
No, I hadn't.
You were on probation for doing that, were you not?
No, I wasn't.
You were on probation for a situation with a court day for a dual relationship, isn't that true?
It's true that I was on probation for a situation involving court day, but it didn't have anything to do with the statement you made earlier about insinuating myself into his life for financial benefit.
That had to do with you bartering therapeutic services for construction work on your home, did it not?
No, that would be an inaccurate description of the situation. If you'd like me to explain it, I'd be happy to.
No, that's okay. Is one of the reasons are dual relationships prohibited in your profession because they allow the therapist to take unfair advantage of someone who is coming to you for emotional or psychological help?
They're to be avoided because there is always the potential that there could be some exploitation or simply conflict of interest in having such a relationship.
And wouldn't one conflict of interest be in a situation where the therapist, who, by the way, the therapist-patient relationship gives the therapist a tremendous amount of power, does it not?
I think that the therapist has power in the therapeutic relationship. I don't know about tremendous amount.
Well, in the sense that the patient is coming to you with some emotional or psychological problem and is looking to you as a professional, correct?
That's the nature of therapy.
And is it true that one reason why dual relationships are prohibited is because the therapist, if he was unethical, could tell that patient that he or she was sick and then use that statement to the patient that the patient continued to need therapy as a basis for maybe getting something financial out of the patient?
You're asking me theoretical, hypothetical questions, and anything on earth, I suppose, is possible theoretically and hypothetically.
Well, for instance, if you had a patient and you needed some construction work done on your home, and the patient was a contractor, one way an unethical therapist could work that situation to his advantage is to tell the patient, you really need to continue to see me, you need long-term therapy here, and if you stay in therapy with me, I'll cure you, and in the meantime, you do the construction on my home.
Objection.
Isn't that one way that an unethical therapist could operate?
Objection assumes that's not an
An unethical therapist could do anything. Are you asking me if that's what occurred?
I'm asking you whether that would be something that an unethical therapist could do to take advantage of a client and to come into violation of this dual relationship rule.
You're asking a compound question.
You cannot answer it.
No, I can't.
And is it true that that scenario which I gave to you is exactly what happened with you in court day? That's why you were on probation?
No, it's not.
Well, did he do construction work on your home?
He did some handyman work around the house, that's correct.
And did you agree as part of the settlement in that case that you were having a dual relationship with him in the sense of trading therapy for his assistance in reconstructing your house?
I agreed that, in fact, at the same time that he was involved in therapy, that he was performing some work around the house as a handyman. That was agreed to.
Yeah, and that's why you were put on probation?
For his benefit.
That's why you were put on probation,
Yes, the
correct?
stipulation said that that my efforts were actually for his interest, and it was an effort to try to help him, and specifically stated it wasn't to exploit him, although it is technically something to be avoided. And there's no way that it was ever found, stipulated, or agreed to that in any way I was trying to harm that patient or any other patient. It simply said that there was a technical violation of that provision, and that was about 12 years ago.
Technical violation which landed you on probation for 5 years, correct?
It didn't land me anywhere, but yes, I was on probation.
And you had a supervisor that was supposed to watch over your work, correct?
There was a supervisor that I met with, that's correct.
And that was Dr. Ludlow, wasn't it?
No, it was Dr. Lulo.
Ludlow?
Yes.
And in fact, I think you testified it was Dr. Ludlow that you called on the night of October 31st, correct?
That's correct.
And he told you could go to the police, did he not?
I don't recall that.
Well, if he did tell you that, would it be your testimony that you intentionally violated the advice that he gave to you?
He didn't advise me to go to the police.
Objection sustained, the answer is stricken.
Did you seek his advice on that night?
I sought his general corroborative opinion about what was happening.
And returning to this idea that you expressed earlier that you called a number of people, he was one of the people that you called and asked what you should do, basically, correct?
That's correct.
And he told you you could go to the police, did he not?
That was one of a number of options that he mentioned. He was not advising me or telling me to go to the police.
And you, on your own, decided not to follow that option, is that right?
Absolutely. He was not making any specific recommendation at all. He was simply trying to define the limits of confidentiality or help me define it on the phone. He was not giving me advice as to what to do.
Now, isn't it true that in addition to Court Day, you had a number of other patients where you had this habit or custom or pattern of establishing a therapeutic relationship and then insinuating yourself into the patient's business affairs at the same time you were telling the patient that he or she was sick and needed your help?
Objection irrelevant, beyond the scope.
Objection sustained.
In your relationship with Judalon Smith, were you in a dual relationship with her?
Absolutely not. She was not my patient.
One of the reasons why you claim in front of this jury that she was not your patient is because that would jeopardize your license. Isn't that true?
No, I claimed and stated she wasn't my patient because she never was my patient.
Well, you admitted under oath you were having a sexual relationship with her, correct?
That's correct.
And you deny that she was your patient, but isn't it true that having a sexual relationship with a patient is against the ethical code of your profession?
Certainly is. She wasn't a patient.
And in fact, you're under suspicion from the State Attorney General's office for that very thing, isn't that true?
For what very thing?
For having a patient-lover relationship with Judalon Smith. Isn't that one of the charges pending against you?
It's a groundless charge, yes.
And you realize that if you admitted in front of this jury that you had such a relationship, that would jeopardize your license, correct?
That has nothing to do with my response, Mr. Burt. Judalon Smith was never a patient. She wasn't, she isn't, never has been, and she's not a patient.
My question is, is it your understanding that if you answer under oath here in court that she was your patient, that could be used in the proceeding that's presently pending against you, filed by the State Attorney General's office? That's my question.
Didn't think about that and wasn't concerned about that or aware of it one way or the other because she wasn't my patient.
Did you have a pattern and practice of getting involved with patients and giving them drugs
Your Honor.
as part of a method that, could I finish the question, please?
There's an objection. It's beyond the scope, and it's irrelevant, and I think there's already been a ruling.
All right, the objection is sustained.
All right. Doctor, at the very end of your direct examination, you testified that you were here under court order, correct?
That certainly is correct.
And I think you also testified in answer to Ms. Abramson's questions that you did not welcome the publicity which was coming your way as a result of this case. Was that your testimony?
It was my testimony, absolutely.
And I think you've already told us that you weren't under any court order when you held this press conference in September, correct?
Well, I was under a court order, but not that one.
Well,
I was under a court order.
Court order to gather a bunch of press representatives at a Beverly Hills hotel and hold a press conference.
No, I wasn't a court order to do that.
And is it true that you also interviewed in September of 1990 for an article in Playboy magazine?
No, that's not true.
Were you quoted at length in an article that was published in Playboy magazine?
I was quoted at length, but I did not interview for that. And as a matter of fact, there was a contractual agreement that was not to be used in any such publication, and it was used anyway.
Well, where did the quotes come from that were in the Playboy magazine article?
Some of the quotes came from me, and some of them didn't appear to have come from anything that I could remember. And there was a specific agreement that it was not to be used, a contractual agreement.
Do you remember you stating in the course of that interview with reference to Judalon Smith, quote, "She might have gotten some information from other sources and then tried to place herself center stage as a person who held the truth in this matter and was a critical witness," end quote. Do you remember making that statement about Judalon Smith?
Yes, I do.
Is that an example of projection?
No, that isn't. As a matter of fact, what I was stating in an oblique way, because of the privilege that existed at the time, was that Judalon Smith would not have gotten her information by listening in at the door, but rather that the information she got from another source was actually me warning her that she was in danger and telling her some of the things that I thought she needed to know that she was in danger. And that what she did is retroactively place herself in the situation in a very melodramatic way and have herself as a central figure listening to all of this, when in fact she never did any such thing and never heard any such thing. The way that she got the information she got was from an evidence code 1024 and a Tarasoff warning, where I gave her the information intentionally to warn her and to try to protect her from being harmed. That's where she got the information, not from dramatically listening in at a door.
And was that another long declarative sentence, which you just gave?
Mr. Burt, I would stipulate that that was a long declarative statement.
And Doctor, is it true that after the search warrant was served on your house and there was some publicity in this case, that you called up a former patient of yours and was bragging to her that you were a big media star in this case?
I don't even know what you're talking about.
Do you know a person by the name of Cynthia McPhee?
Cynthia McPhee? That's
Yes.
not a patient of mine.
Do you know her?
I knew her at one point. She's definitely not a patient of mine.
She lived in your house for about 5 years, did
She's
you?
a housekeeper.
For 5 years.
Yes, for a long period of time.
And your testimony is she was not your patient.
She absolutely was not my patient.
And after this case broke in the press, did you call her up and tell her you were a big media star now?
No, I did not. As a matter of fact, she called me. I don't recall calling her.
Did you ever place a phone call to her in Vancouver, Canada, in which you were bragging to her that you were a big media star as a result of this case?
I do not recall any such thing ever happening.
Do you remember a tape-recorded conversation you had with Judalon Smith that was made at the request of the Beverly Hills Police Department in March of 1990?
Could you please repeat that?
Yeah. Are you now aware, as you sit there, that Judalon Smith was asked to wear a body wire for a meeting that she had with you, where you two had a conversation on March 7th, 1990?
Yes, I know that she wore body wire.
All right. And you've seen at some point a transcript of that tape-recorded statement that was made as a result of that body wire, have you not?
I don't know that I ever saw any transcript of any of that.
Do you remember saying to Ms. Smith during the course of that meeting on March 7th, 1990, you read People magazine? Read People magazine. Did you read it? Smith, no, I didn't. Oziel, well, you're not in there, but I am. Smith, so you love that sort of stuff. Oziel, fuck you and anything that looks like you. Do you remember making that statement?
No, but it probably was appropriate at the time.
Probably was what?
I don't remember making the statement, but it didn't have to do with liking media. It had to do with not liking media attention. And when I said you weren't in there, I was, what I meant was you went to the police and initiated all of this. And basically, my name is in People magazine. It was not a way of stating I like publicity. It was quite the opposite. I was stating I didn't want the publicity.
Did you have a friend by the name of Cynthia that you contacted about Patricia, about a possible screenplay idea that you had for this case?
No.
Do you know a person, a friend of yours, by the name of Patricia?
I didn't contact anybody about a screenplay with respect to this case, period.
How about a movie idea?
No way. Didn't do it.
That involved somebody who was making threats to a psychiatrist on an airplane.
I never talked with anybody about any movie that related in any way to the Menendez case, period.
And never any script ideas about what you characterize as a fictional scenario of a psychiatrist who hears a confession on an airplane of a guy who is very prominent?
I don't recall any such conversation, but if there ever was any conversation about any kind of script, it had nothing to do with the Menendez case.
Dr. Oziel, what did you do before you became a psychologist?
Correction or relevant?
Overall.
What did I do before I became a psychologist?
Right.
I've been a psychologist ever since I graduated from school, so I can't really relate to that.
You started as a playwright, did you not?
I had an English writing minor in college as a playwright, but I didn't start as a playwright.
Well, didn't you start as a playwright and got a play published and got paid $50 for it?
That probably sounds like it could have happened, but that was while I was in school. I didn't begin a career as a playwright.
All right, and isn't it true that the reason you went into psychology was that it was the closest thing to writing plays?
I wouldn't say that that's a complete reason that I went into psychology.
Was that one of the reasons you went into it?
I thought that it dealt with feelings and people, and feelings and people were of interest to me, and that's part of the reason I went into psychology.
And one point in your November 2nd notes, you wrote this, did you not? This is on page 14. I then asked if they felt...
Excuse me, could we just have a chance to get the reference, please? Which part are you referring to?
Page 14,
Yeah.
second paragraph.
Your Honor, this was only presented to one jury.
That's not true. It's at page 9416 and 9398.
People want to change their position, or?
No, you're indirect.
Okay, hold on a second. What, page 14?
Yes.
Which paragraph now?
The first full paragraph starting with, I then asked.
Okay, hold on a second. Okay, my notes indicate that it was on the list.
I would have to object.
I have that page.
We can approach you.
Sure. Well, let me just rephrase the question if I could, Your Honor. Recall at one point in your notes indicating that Lyle laughed. That Lyle laughed.
Sardonically, is that?
Yeah, don't
Right.
you indicate in this Lyle laughed rather sardonically?
Yes, I do.
Were you writing a play here, Dr. Oziel?
No, I wasn't.
Okay, that's all right.
All right, let me see counsel up here regarding the balance of this witness's testimony. All right, we'll be in recess until tomorrow at 9 o'clock, ladies and gentlemen. Proceed, and I believe the parties are calling a witness out of order, is that correct?
Yes, Your Honor.
All All right. Although Dr. Oziel is still on the witness stand and will be resuming the witness stand for further examination, the people at this point are calling another witness who will testify this morning, and when he completes his testimony, then we'll resume with the examination of Dr. Oziel. You may call your next witness.
People call Dr. Jeffrey Lulo to the stand.
Please raise your right hand.
with an affirmation.
You need not raise your hand. You do solemnly affirm that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth. This you do under the pain and penalty of perjury.
I do.
Please take the stand and state your name for the record.
My name is Jeffrey Lulo.
Spell your last name, please.
L-U-L-O-W.
And your first name?
Jeffrey, J-E-F-F-R-E-Y.
All right.
Thank you. Dr. Lulo, what do you do for a living, please?
I am a psychologist
How long have you been a psychologist?
for 20 and a half years.
Excuse me, 20?
20, yes, sorry.
And in the period of time, 1986 through 1989, where were your offices located?
At 450 North Bedford Drive, suite number 203 in Beverly Hills.
On Halloween night of 1989, did you receive a phone call from someone that was known to you?
Yes.
And do you remember about what time of day it was that you received the phone call?
I may have received several phone calls. Are you referring to a particular one?
Yes, a phone call from Dr. Jerome Oziel.
I don't remember the time. I do remember it was dark and was after my children had returned from trick-or-treating.
Now, at the time, did you have small children under the age of about 8 or 9?
Yes.
Had you taken them trick-or-treating?
Yes.
You were aware of the fact that it was Halloween?
I was aware.
Right. And when you got this phone call, do you remember where you were inside of your home?
No. I remember where I was sitting when I was speaking on the phone, but I don't remember where I was when the phone call came.
From where did you speak with Dr. Oziel in your home?
I had a phone at my desk in the living room.
And did you have a conversation with Dr. Oziel on the night of Halloween of 1989?
Yes, I did.
And at that time of 1989, approximately how long had you known Dr. Oziel?
I had met him in June of 1986, so that would have been about 3 years and a few months.
What did he say when he called you on the phone?
I don't remember the words specifically, but I do remember that he informed me that he called because he was concerned about an issue that touched on ethics and wanted to know if I could talk to him about it and see if I could help him out with it.
Then what happened?
I told him that I'd be happy to talk to him, words to that effect, and he told me that he did not want to tell me too much because he didn't want to betray a confidence that he had received in the course of his practice, and he did not want me to become involved in something that might potentially become dangerous.
At the time that you began to speak to him, did you notice anything about his demeanor over the phone? Did you notice anything about his tone of voice or anything like that?
Yes.
What did you notice, please?
I noticed that he spoke with some urgency. His words were clipped. There was some pressure of his speech.
After he told you that he didn't want to give you too much information, what next transpired during this conversation?
He told me that he had been seeing a young man who had told him that he and his brother had killed somebody.
Then what happened?
He asked if he had told me too much, if that was something that made me think I knew what he was talking about, and I said no.
Let me ask you a question. On August the 20th of 1989, approximately 2.5 months before, did something happen of significance in your own life?
Yes.
What?
My father died.
And at that time that your father died on August the 20th of 1989, were you present in the hospital?
I was present in the hospital for most of the week before that and dealing with the funeral for most of the week after that.
Did you read the newspapers during the period of time, the week before and after your father's death?
Apparently not. I don't remember too much else that I did. I went to the office when I could, and I dealt with the family matters of my father's health and I don't remember too much else about that time. Apparently, I wasn't reading papers.
When Dr. Oziel informed you that he'd had a patient who had made this statement that you related to the jury, did you connect that up with anything you'd heard about in the media?
I hadn't heard anything in the media that, I mean, people are in the media being killed all the time, every day, unfortunately, and that didn't make any particular connection to me.
Okay, now after that, what happened next?
He told me that that one of these brothers had told him about having done this killing, and that the other brother, who was older, had come to his office apparently later, after he had first heard about this, after Dr. Oziel had first heard about this, and that there had been some talk at the office as to concern on these brothers' parts as to whom Dr. Oziel might tell about this, that it was no longer safe for them, that he had told somebody, and he had told them that because of the ethics under which he worked as a psychologist, he would not be able to tell anybody, and that he would not.
All right, then what happened?
He was concerned about two issues. Again, this is a phone conversation from 1989, so I remember the gist of it, but not the exact words. But I remember there were two issues he was concerned about.
And what were those two issues?
Well, excuse me, can I object to the question is vague? Is he giving his impressions or what Dr. Oziel said to him?
All right, can you clarify that, please?
Okay, did you have discussion with him on two particular subject matters that you specifically recall?
Yes.
And what were the two subject matters that you specifically recall?
One had to do with his ethical responsibilities and the ethical constraints on him in such a situation, and the other had to do with his own safety and the safety of his family.
Did you and he address the issue of the ethics?
Yes.
And what was the conversation and what was your advice?
He brought up a case called Tarasov, which has to do with warning intended victims of violent crimes.
Now, at the time that he brought up the case of Tarasov, were you familiar with the Tarasov case?
Every psychologist has to be familiar with the case. I was very familiar with it.
And could you briefly tell the jury what your understanding of Tarasov was in 1989?
I'm sorry, I didn't hear you.
Could you briefly tell the jury what your understanding was of the Tarasov case?
Tarasov case, as I understood it, required, the outcome of that case required that a psychologist or other mental health professional take steps to warn the intended victims of violent crimes of their danger, and to alert the police or other law enforcement agencies that might be of help in preventing such a crime from being taken place. This was expanded in a later decision to include people who might potentially become harmed if this act is carried out.
All right. And
that was the Headland case.
In the Tarasov case, did that deal with danger to someone other than the psychotherapist or the patient?
Yes.
Did it deal with danger to a third party?
Yes, it dealt with danger to a third party.
And did Tarasov indicate that if a psychotherapist did not warn a third party of an impending danger, that the heirs of that third party, should the third party be killed, could sue the psychotherapist?
That was my understanding, although I'm not an attorney.
All right, but that was your understanding as a psychologist, correct?
That was my understanding.
And you are, in fact, a psychologist and not a psychiatrist.
I'm a psychologist.
Okay. What else did you talk about with Tarasov with Dr. Oziel?
Well, he and I were discussing whether that case and the Headland case that I mentioned that expanded that to people who might reasonably be in danger applied when the intended victim is the psychologist or the therapist himself.
What else did you talk about?
Well, I said that I thought that it certainly was not going to extend more protection to someone else than it would to the therapist and his own family, and that I thought that the requirements of Tarasov, in my opinion, as a psychologist, applied in this case, and that he could legitimately take steps to protect his safety and the safety of his family if he felt them to be in danger.
What else did you talk about?
We talked about whether he could, what he could tell the police should he contact the police.
Now, who brought up the idea of talking to the police first, you or him, as best you can recall?
I don't recall.
All right. And so there was a discussion as to whether or not the police could be informed, is that correct?
Yes.
And did you give him any indication as to whether or not he could ethically go to the police?
Yes, I did. I suggested to him that he could talk to the police, but he could not divulge to them the content of his discussions with these men beyond what was necessary to protect himself and his family.
Okay, did you and he go into any details about how much detail he could tell the police?
I didn't want to know any more detail, so we didn't go into more detail.
All right. Did Dr. Oziel give you any indication about whether or not he wanted to go to the police or how he felt about that, or did you have any further discussion along these lines?
Yes, we did.
I'm going to object to this, Your Honor, as hearsay with no foundation.
Overruled.
We did talk about that. Dr. Oziel expressed a concern, a couple of concerns. One was that the police might not take it seriously enough, and secondly, that whatever protection they might offer would end at some point, and that he and his family would still be in danger, potentially.
What else did you talk about?
I'm going to object to that, Your Honor. Calling for hearsay, no foundation.
Be more specific, please.
All right, I believe you indicated that Dr. Oziel had two concerns. One was ethical concerns and one was suggestions as to his safety. Is that correct?
That's correct.
Did you have any further discussion with him about the ethics of what he could do?
No.
All right, did you have any further discussion about suggestions as to protective measures he might be able to take?
Yes.
Okay, and what else did you talk about in addition to talking about the police?
I'm going to object to that also, Your Honor. That's hearsay with no foundation.
Objection overruled.
I made a suggestion to him as to something he might do that would not violate the confidentiality of the discussions with these men and might also serve to protect himself and his family.
And what did you suggest to him that he do?
Well, I suggested a few things.
What's the first?
The first thing was that he tell his wife to take the kids and go on a vacation immediately.
Okay, what else?
That he hire someone to watch the house.
What else did you suggest?
That he hire someone to watch him, protect him, bodyguard.
Did you use the term bodyguard?
Yes, I believe so.
What else did you tell him to do?
I suggested that he write down in detail everything he had told me, plus whatever he had learned in the sessions from these men. That he put it in great detail, that he dated, that he put that writing in a safe deposit box.
Did you tell him what to do in regards to the safe deposit box?
Yes.
What did you tell him?
That he provide his attorney with a key to the box, with the right to open the box, that he sign whatever he needed to do to let his attorney open the box, that he also direct his attorney that if anything should ever happen to him or his family, that the attorney was to open the box in the presence of authorities.
Did you give him any suggestion as to whether or not he should convey these measures to the people who had threatened him?
I specifically suggested that he tell these men that he had done that, so that with the idea being that they would recognize that his safety was their concern, that they would be better off if he were safe, but also indicating that by doing it in this way, he had not divulged to confidence.
Now, at the time that you had this conversation with Dr. Oziel, do you recall if all the Halloween activities were already over?
We always had stragglers coming in trick-or-treat. They always seemed to be older than the kids who came earlier, and so we had people coming to the door now and then.
Was that after the phone call with Dr.?
Object to this is irrelevant.
It's just pin the time, Your Honor.
Overruled.
I don't recall precisely if anybody did come on that night or not. We generally did, but I don't know.
All right. Dr. Lulo, when was the first time you were contacted by any of the attorneys in this case regarding the activities of Halloween of 1989? And by whom were you first contacted?
I was called on, if I can look at my appointment book, I can probably tell you the day.
All right. Do you have your appointment book?
Yeah. I believe it was Wednesday, August 4th.
Do you remember who it was that called you?
I didn't get his name completely. Mr. Burke, is that the name? Represents Lyle Menendez, he told me.
All right, and that was the first phone call you've gotten from any of the attorneys in this case, is that correct?
That's correct.
And then you were called subsequently by either myself or someone on the prosecution team, is that correct?
That's correct.
So your first contact then was from the defense, correct?
That's correct.
Now, how was it that you knew Dr. Oziel?
I have a concern that divulging that may violate a confidence. So I'd rather that the court tell me whether or not I can divulge that.
Does this have to do with probationary status of Dr. Oziel?
Yes, it does.
Okay, you may.
I'm ordered to do
Yeah.
so? Thank you, Your Honor. I was selected by Dr. Oziel to supervise him when he was on probation with what was then called the Psychology Examining Committee and now is called the Board of Psychology.
And in that regard, were you employed by the Board of Psychology to conduct the supervision, or how were those arrangements made?
The Board of Psychology apparently provided Dr. Oziel with a list of psychologists from whom he could select someone as his supervisor. He selected me, and he would be paying me for the time involved in the supervision.
Did you first meet with him in June of 1986 in regards to his probationary status?
Yes.
And did you conduct interviews or sessions with him for once a week for a period of a year after that?
Yes, I did.
What was he on probation for?
Again, Your Honor, is that something I can answer?
Yes.
He was on probation for what's called a dual relationship. He had had a relationship with a patient in it.
Excuse me, Your Honor.
Okay, let's hold on. They're having some electronic problem here.
Is it possible for me to get some water?
Sure. Get a little water for the witness. Well, how is the reporter's,
Plugged in also, there's 2 plugs in.
well, we working now? Lynn, or?
Does this microphone need to be positioned differently?
No, you're okay. It's just some hearing device for one of the jurors. You okay? Okay, let's go. All right, you may resume your examination.
I believe the question was, what was Dr. Oziel on probation for? Could you factually explain what it was?
He had a patient whom he was seeing, who said he was unable to. Thank you. Was unable to pay Dr. Oziel's bill, and after some discussion with this patient, Dr. Oziel had arranged with.
At this point, I'm sorry. You can do your defense. I'm going to object to this as hearsay and irrelevant.
All right. The details of it are sustained.
Okay. Did Dr. Oziel tell
Go
you?
ahead. Your
Did
next
Dr.
question.
Oziel tell you what he was on probation for?
Again, Your Honor, is that something I can divulge?
Yes.
Dr. Oziel did tell me what he was on probation for, but I had also received documents from the Psychology Examining Committee telling me.
And did he was on probation for having a patient do work on his home in lieu of paying for services, is that correct?
Objection, Your Honor, that's hearsay.
Sustained.
What did Dr. Oziel tell you he was on probation for?
Objection, hearsay.
Prior consistent statement.
No. Doesn't get impeached on what he was on.
Okay, counsel, let's not argue the matter. The objection is that this is hearsay, it's being offered for the truth, is it?
Yes, as a prior consistent statement.
All right, the objection is overruled. You can answer the question.
Dr. Oziel told me that he was on probation. Wait, well, I forgot what the question was.
Okay.
I was answering some other question.
Very briefly, okay, very briefly. What did Dr. Oziel tell you as to why he was on probation?
He had had a patient of his do some work on his house while the man was still a patient,
In lieu of being paid money?
in lieu of paying Dr. Oziel's fee.
Did you write 4 quarterly reports on Dr. Oziel's behalf?
Yes, I did.
Objection, relevant.
Overruled.
And were these reports favorable?
Objection, hearsay.
Sustained.
Did you recommend a successful completion of Dr. Oziel's probation?
Objection, hearsay.
Sustained.
May I make an offer, please?
Yes, you can do that at the sidebar.
Yes.
All right, you may continue your examination.
Dr. Lulo, I believe you indicated that you first met Dr. Oziel in June of '86. Is that correct?
That's correct.
Now, in October of 1989, jumping ahead some period of time, how long had it been since you had seen or heard from Dr. Oziel?
I had heard from him, I believe, the previous summer, but I don't remember when. 1989.
Okay, and prior to that, how much contact had you had with him?
I had not heard from him since I stopped supervising him in June of '87.
Okay, I have no further questions of this witness.
Cross-examination.
Dr. Lulo, I noticed when you were asked the question of when you and I spoke, you had a book in your hand that you looked at, and you then gave us the date of August 4th as the date when you and I spoke, correct?
Are you Mr. Burke?
Yes.
Oh, okay. I don't know who you are.
I'm sorry, I'm Mr. Burke. How do you do?
Yeah, that was my best estimate. I don't enter it in the book. I was trying to remember by whom I had seen that day. So it may have been the day before or the day after. I don't recall.
Did you make any notes of the conversation you say you had with Dr. Oziel?
Which conversation?
Well, the prosecutor questioned you about a conversation on Halloween, and you explained how you were out with your kids trick-or-treating. So that's the conversation you're here to testify about.
Okay.
And my question was directed to that conversation.
Made no notes.
Made no notes. And you at that time were Dr. Oziel's, in effect, probation officer, were you not?
I, at that time, had no connection with Dr. Oziel whatsoever.
When did you become Dr. Oziel's probation officer?
Well, I was never his probation officer. I was his supervisor.
He was on probation.
That was not a matter between him and me. I was his supervisor. That was the role that I served.
Was he on probation? Was that your understanding?
I don't recall the details of that, whether it was probation or whether his license had been revoked and it was stayed. I don't recall the details.
Well, what was your understanding of what you were supposed to be doing with him?
My understanding, during the time that I was supervising him?
Yes.
I was supposed to be, in effect, monitoring his practice, both in terms of the nature of what he did in his practice and any ethical considerations that came up, and reporting to the Psychology Examining Committee quarterly regarding these meetings.
And was it your understanding of your relationship with Dr. Oziel that he was going to be looking to you for advice on certain ethical questions that he might have?
During the time that I was supervising him?
Yes.
Well, he could look to me. He could actually talk to any of a number of people. These sessions were a weekly thing, so it was an easy thing if there was an ethical question that came up to ask me about it and to discuss it with me.
And I think you said you first began seeing him on probation on June 2nd, 1986. Is that?
I don't recall the date that I did it. It was in June of '86. I do know that.
And when did you stop seeing him?
It was a one-year period of supervision that he had to have, so I believe it was either the end of May of '87 or the beginning of June.
And after that period of time, I think you indicated you had no further contact with him? He never called you again?
He didn't call me until sometime in the summer of '89, I believe it was. That's an imprecise time in my mind.
So after your involvement with him in May of '87, the next time you heard from him was in the summer of '89?
That's correct.
And was that the telephone conversation on Halloween night?
No, Halloween's in the fall.
That's true. What was the conversation you had with him in the summer?
He asked if I could refer him to psychiatrists or psychologists to help him with the matter that he was involved in.
And did you in fact refer him to a psychiatrist or a psychologist?
Both.
And who did you refer him to?
Dr. Franklin Drucker, psychiatrist, and I believe Dr. Bruce Sutkus, S-U-T-K-U-S, a psychologist.
And then the next time you heard from him was in August of, October of 1989?
That's correct.
Now, have you been in contact with him since that conversation in October of 1989?
I believe I had, you asked me this on the phone, and I said at the time, and what I said at the time to you was that I'm not clear. I think I did have one further conversation, but I don't remember it. I don't remember anything about it except that I talked to him, and I think his wife was also on the line.
And have you seen him socially at all since then?
I never saw him socially, ever.
This information you say you gave to him, you told him that his wife should go on vacation, is that right?
I suggested that his wife and children, whoever was in the household, should go somewhere else until things had settled down, yes.
All right. And by the way, that's not information you provided to me when you and I spoke, was it?
I answered all your questions when you asked them.
By the way, that's not information you provided to me when we spoke, is it?
No, I didn't give you any information you didn't ask for.
And again, once again, you did not give me that information that you told him that his wife should go on vacation. Yes or no? It's very simple to answer.
No. As I said before,
Thank
no.
you. And you didn't tell me in that conversation that you advised him to get a bodyguard, did you? Yes or no?
I don't recall whether I told you that or not.
Did you tell me in that conversation that you advised him to write down in detail everything he did?
I don't recall what your questions were. I know I answered your questions. I don't recall whether you asked me that or not.
You recall telling me that there were certain things that you would not discuss with me?
Yes.
And was this one of the things you didn't want to reveal?
I didn't think that I could talk about the content of any of my supervisory sessions with Dr. Oziel.
Right, but
That's what I had in mind when I said that to you.
But you were free to tell that to the prosecutor, is that
Free
your
to tell what?
understanding?
I'm sorry, free to tell
You
what?
were free to tell the prosecutor that information?
Of course not.
Didn't you meet with a prosecutor before you came to court
Yes.
today?
Yes.
And didn't you tell her this information that you just revealed to the jury?
Could we have it clarified what information you're talking
The
about?
information about advising Dr. Oziel to get a bodyguard?
Now, you're mixing two things up.
Did you tell her the information about advising Dr. Oziel to get a bodyguard? Yes or no?
Yes, I did.
All right. And did you tell the prosecutor the information about advising Dr. Oziel to write down in detail everything he did?
Yes.
Did you tell the prosecutor that you advised Dr. Oziel that the police could, in your opinion, be contacted under the Tarasoff decision?
I think I said, yeah, I told her that. I think I told you that, too.
All right. Now, was it your understanding when Dr. Oziel called you that his ethical dilemma was he wasn't sure that Tarasoff extended to a situation that involved a threat to the therapist himself?
That was part of his concern.
All right. Did he indicate any misunderstanding that Tarasoff did or did not apply to a threat to someone else?
My recollection is that he understood that Tarasoff applied if someone told him they were going to do harm to somebody else, period. And that under those conditions, he had a duty to warn the person. But when the threat was to himself, he was unclear.
All right. So if the threat was to a third person, at least based on your discussion with him, he understood that it applied there. The ethical question was, well, what about if the therapist is threatened?
That was one part of the ethical question. The rest of it was what could he divulge in order to protect whoever had to be protected. Some of this was really an airing of views more than seeking my word. I didn't have any authority to tell him. It was just airing the views and getting my suggestions.
And you basically, if I understood your testimony correctly, told him that he could divulge to the police whatever was necessary to protect himself or his family, correct?
Only that which would be necessary to protect
Himself and his family.
Yes.
And he never discussed with you that there was anyone else involved besides himself and his family, did he?
I think he had a housekeeper. I kind of assumed that person, if he did have a housekeeper, would be included at the household.
In other words, he mentioned that there was a housekeeper that may have been in danger as well.
No, he didn't at that time, but when I was supervising him, he had mentioned the presence of a housekeeper. So when I talked to him in '89, I figured there might be a housekeeper, so that person was in my mind as well.
And did you mention that? In other words, as you were discussing the situation, did you say something along the lines of, well, you can do whatever it takes to protect yourself, your family, your housekeeper, whatever?
No, I never said you can do whatever it takes. I never said that.
Did he mention to you that he had a girlfriend that he was worried about?
Never heard any mention of a girlfriend.
Did he mention to you that there was a girlfriend sitting in the room with him as he was discussing the confidential information that he was discussing with you?
As I just said, there was no mention of a girlfriend in any relationship to anything at any point, at any time between Dr. Oziel and me in that conversation.
And so he never mentioned any ethical problem with regard to divulging any information to a girlfriend or anybody like a girlfriend,
I
right?
think that goes without saying based on my last response.
All right, you can just answer the question, okay?
I think I did.
Good, thank you. Now, did you indicate that Dr. Oziel said to you that he had told the patients that he couldn't tell anyone what they had told him?
That he had told them that he couldn't tell anybody about having told him they had killed somebody.
Basically, he explained to you that he had explained to the patients that what they had said was confidential.
Yes.
And that was all he said about what he had explained to the patients about confidentiality, right?
That's correct.
And when you and I spoke on August 4th, did I tell you that for the first time since this litigation began in 1989, Dr. Oziel mentioned your name for the first time in testimony here before this jury?
Objection, hearsay, irrelevant, what he said.
This is for a non-hearsay purpose. Were you aware that your name came up in this case for the first time the other day in front of the jury?
I have no idea when my name came up or didn't come up.
And prior to my calling you on August 4th, did Dr. Oziel ever contact you and say, I want you to testify in a hearing or before a court to explain to the court that you were the one that came up with this idea about?
Never. I haven't spoken with Dr. Oziel for years.
And do you know if Dr. Oziel followed your advice that you gave to him
I
about
do
hiring
not.
a bodyguard? And
I do not know.
thank you. That's all I have. Dr. Oziel ever express any concern for his business partners?
Objection, Vegas, is October 31st.
October 31st.
I don't know whether he had business partners nor whether they were threatened.
So you don't have any specific recollection of him saying to you, I got people in this office who are also threatened. What do I do about them? Words to that effect.
I don't remember him saying words to that effect.
Do you know who supervised Dr. Oziel for the remainder of his probation?
I don't know whether there was any remainder of the probation.
What was your understanding as to how long the probation was when you were dealing with him? Was it 5 years?
1 year.
I think that I'd object to hearsay.
Overruled.
My understanding was that I was to supervise him for 1 year.
What did you do to supervise him?
I met with him weekly, discussed, without divulging any details of that had been given to him, issues that may have come up in his practice that were ethical, discussed some ethical issues that may have come up in my practice as illustrations. That was what we did.
And then he was to pay you a fee for your time,
Certainly.
is the way that worked?
Certainly.
Thank you.
Ms. Abrahamson.
Dr. Lulo, as part of the discussion that you had with Dr. Oziel, did you advise him to tell these patients, these particular two patients, that since confidentiality was limited and since they had threatened him, there was no further confidentiality?
Let me think. I know I didn't say that.
Wouldn't that, in your opinion, have increased any potential danger, assuming there was any?
Objection calls for speculation.
Did you have any such opinion at the time?
I did not have the opinion that confidentiality had gone out the window with the threat. That was not my opinion at the time. Again, I'm not an attorney. I'm a psychologist trying to deal with a problem with another psychologist.
I'm trying to focus you, though, on the advice that you gave Dr. Oziel about how to take some measures to make himself feel safer, okay? You had suggested that he write detailed notes, that he put them in a safe place, that he give an attorney access to them, correct?
Correct.
And you also advised him that he should tell the patients, basically, I have these notes, therefore it's in your best interest if nothing bad happens to me, in effect.
In effect.
Okay. And he told you that he had assured the patients of confidentiality, and that too was a safety effect, was it not?
He told me that he had assured them of that, but my understanding from what he told me was that he assured them of that before the threat was made.
Okay. And did he tell you that he had no further conversation with them about confidentiality after the supposed threat was made?
I'm sorry, there was a cough there. I couldn't hear you.
Did he tell you that there was no further discussion about confidentiality after the supposed threat was made?
We didn't talk about anything else about the session or sessions he'd had.
Okay. You were supervising him to monitor his ethics, is that right? Because his violation was an ethical violation.
Yes.
You weren't there to supervise his competency, were you?
Well, only as ethics touch on competency, of course.
Okay. But you weren't, for example, privy to his patient notes. You weren't reviewing whether his therapeutic contracts or assessments or diagnosis or therapeutic plans for each of his patients were fit the standard of care for competent practice.
Only insofar as that information, in a very vague sense, became relevant to discussing ethical issues.
Do you recall how many patients Dr. Oziel had in 1986 through 87 when you supervised?
Objection calls for hearsay irrelevant.
Overall. I have no idea how many patients he had.
Were you aware in 1987 that he went into business with a patient?
Objection calls for hearsay. Hearsay.
Objection overruled.
I know nothing about going into business with a patient.
If he had gone into business with a patient, would that have caused you some concern given the fact he was on probation for a dual relationship?
It would have given me concern for anybody, whether or not they're on probation. You're not to do that.
Now, when you and Dr. Oziel were discussing Tarasov, well, we'll strike that. You've testified you told him he could divulge to the police what was necessary to protect himself. Now, that's the standard of Tarasov, isn't it? You divulge what is necessary to protect.
That's my understanding,
Okay.
yes.
And Tarasov basically is the case that established civil liability, the ability to be sued and pay money if a therapist fails to warn a third party that they have been threatened by a patient.
That may be its import for the law. The import for psychologists is you've got to warn and you've got to protect.
Okay, but it has two impulses. One is, what Tarasov really said was if you don't warn, you can get sued. You can be held responsible.
That's a legal understanding of it. My understanding was you got to warn, you got to protect people.
Okay, you also have to have malpractice insurance, don't you?
I don't believe you're required to.
But I'm saying if you're concerned about Tarasov, that's a concern that leads to malpractice insurance because you could get sued for a lot of money.
I don't know. I have malpractice insurance because I think it's a good thing to have.
Okay. Do you know if Dr. Oziel had malpractice insurance?
Objection irrelevant.
Sustained.
Now, you told him to write detailed notes. Did you intend that he should write notes that were accurate?
Certainly.
And is it your understanding as a psychologist that notes are likely to be most accurate when they are written closest in time to the events that they detail?
Objection beyond scope.
Overruled.
It's an interesting question. It actually has two parts to it as far as a psychologist is concerned. With respect to the actual words that are said, I'm sure it's more accurate closer in time. But in terms of an understanding of the import of what somebody says, very often that becomes clearer as time passes.
And as you have more contact with the person. Is that
Well,
right?
sometimes just thinking about it.
Okay.
Sometimes just having your own experience that touches on the issue.
But the practice of keeping notes, psychologists keeping notes, okay, is there some ethical notion that they should be an accurate reflection of what goes on with a patient in a therapy session?
Well, again, there's two questions there. I'm not aware of any requirement regarding the keeping of notes. That's an issue that is being hotly debated in psychology at present. What standards, if any, should there be for note-taking? But certainly, I think it's only reasonable to require that any notes that one takes be accurate.
Did Dr. Oziel indicate to you that he was going to follow that piece of advice and sit down and write detailed notes?
He said that he thought it was very good advice and that he was going to do that.
Are you familiar with any of the research in memory and the retention of memory over time?
Your Honor, this is beyond the scope.
Objection sustained.
Did Dr. Oziel indicate to you before you got off the telephone with him that night that he was going to call the police?
I don't recall whether he indicated that he'd call the police, that he would call the police or not.
Thank you. I have nothing further.
Any redirect?
Just briefly, Dr. Lula, I believe it was your testimony on cross-examination that you did not make any notes of this conversation. Is that correct? The one from October the 31st?
That's correct.
And yet, do you remember the conversation?
Argumentative.
Overruled.
I do recall the conversation.
How come?
It was a dramatic conversation. It was reinforced in my memory when I saw a news report on CNN in March of 1990.
Was this a unique type of conversation for you to have with another psychologist?
Was unique till yesterday when I had another such conversation.
But up until yesterday, was this a unique experience for you?
Up till yesterday, it was unique.
Thank you. I have nothing further.
Anything else?
You say you saw something on television which reinforced the importance of this in your mind?
Yes.
Did you at that point think it was important enough to come forward and tell people you had some information regarding this case?
Did I think it was important enough to cause two questions? I thought it was important. I didn't think that, as a matter of fact, I was watching CNN with my attorney, and my understanding was I had no responsibility to do anything at that point.
Or at any point?
At any point. Except to come here when I got a subpoena.
Now, I want to clarify one thing. Did you tell Dr. Oziel that he should write down immediately his impressions?
I don't recall whether
Overruled.
I don't recall whether I suggested a time frame. I suggested a course of action that at the time I thought made sense.
And in terms of the conversation you had with him in this specific situation, you testified that sometimes your impressions as a therapist will get better with time. Is that the same situation as someone who comes in, say, and threatens, and you're trying to document what the circumstances are of that threat?
If you're
Or were you talking in terms of a diagnosis or evaluation of the patient?
Right. I'm saying that what I said was that I think that in terms of the specific things that were said, it's probably more accurate right after. If that's what I'm doing in my notes, then I would want to do it right after. If what I want to do is try to understand it, I might not want to write anything down for a little while.
Okay. And so in a situation, say, where there's a threat made, because of the ethical ambiguity of what a therapist can do, it might be important to sit down and get the actual words of the threat down right away, because that's something that maybe is going to come into play later in terms of what the therapist does in terms of warning and disclosing and whatnot, correct?
I don't know. My understanding is I'm not here as an expert witness on memory. I would write it down right after.
All right, anything else? Okay. Thank you. You may step down. You're excused. All right, let me see counsel at the sidebar regarding the next examination. Sure. All right, we'll take a recess then, ladies and gentlemen, until 11 o'clock. I was just conferring with the attorneys regarding the scheduling and as far as what we're next doing here. And since there is going to be some examination of Dr. Oziel before only one jury and not the other jury, I was trying to ascertain from the lawyers when precisely we'll do that. But there is still further examination of Dr. Oziel before both juries, and because of that, we'll proceed with that next, and that will be examination by the prosecution called redirect examination. So we'll take a recess and we'll resume at 11 o'clock. Don't discuss this case with anyone. Don't form any final opinions about it, and we'll resume at 11 o'clock. Juries are not yet present. Counsel had a matter that they wanted to discuss before the juries come in. And that had to do with one document that people intended to offer. Is that right?
That's correct.
All right. What is the offer of proof in regards to that particular document? Why is it relevant?
Well, with respect to this document, Dr. Oziel's credibility, I think, has been questioned by the defense. In particular, they claim...
What makes you say that?
In particular, Your Honor, the defense claims that Dr. Oziel was obsessed with Jerome Smith. They have gone so far as to play tape recordings of him calling her up. These documents indicate the nature of the initial call from Jerome Smith to Dr. Oziel, which was business in nature. That is, she solicited Dr. Oziel's business.
No, I'm just asking about that second document dated 7/18/89.
With respect to that happens to be a medical report. My understanding is that Jerome Smith, as Dr. Oziel has testified, was obsessed with Dr. Oziel. She wanted to have sexual relations with Dr. Oziel. Dr. Oziel at that point said, I have a wife, I don't want to endanger my wife. Jerome Smith at that point presented him with a doctor's report indicating that she was HIV negative. That goes hand in hand with him saying that she was obsessed with him. The following letters are just a sampling of letters that Dr. Oziel received in which Jerome Smith professes her undying and timeless love for him. And they're an indication of his state of mind. That is, he's basing his state of mind, his testimony from this witness stand, that he believed that she was obsessed with him based on some of these letters. So I think they're highly relevant in this case, and inasmuch as the defense has injected the relationship into the case, I think that in order to rebut their claim that she or he was obsessed with her by way of even these tapes that they presented to the jury, I think we have a right to counter that with the indications in these letters which indicate that she was obsessed with him. And I don't think it will take very long. I will just question.
Okay, again, we're not talking about the letters, we're talking about just this one document. So you indicate that it has something to do with her state of mind.
Exactly. In fact, she indicated to him that she wanted to have sex with him, and he required that she present him with indications through medical records that she was not, or that she was HIV negative. So I mean, I think that's highly relevant in her pursuing him as he has testified.
If I may.
And also, Your Honor, I think, if I may, I think that there are women jurors, and this is my own belief, women jurors on these panels who would find it horrible that a married man would have sex with another woman in an affair without taking measures to protect his wife.
I mean, that's what would cause them to have this response, the absence of a test? Otherwise, the jurors wouldn't have that reaction?
No, I think that this shows, and the reason why I think this is important is that the jurors are just regular humans. They have their own feelings about things, and I think that once they find out that Dr. Oziel obviously had these extramarital affairs, but he took steps to protect his wife. And I think it's important for the jurors to know that.
All right, what is the defense response?
Well, I just want to make it clear that we did not inject his relationship with Ms. Smith. He offered that as a reason why he disclosed to her. Otherwise, I think the court has a very decent sense of people's privacy. I don't think I have to address that in court.
All right. Basically, the defense position is it's an invasion of Ms. Smith's right of privacy in regards to this. It's a negative test. It's not a positive test, so it doesn't disclose anything of her character or nature that is something that would cast her in a bad light because of the result of the test in any way.
But it's still awfully sleazy to get down to AIDS testing in order to dispute the nature of the relationship. They have their little pile of letters and we have ours.
Right.
I mean, you really want to get, pardon me, I mean, if we're going to start fighting out over who's had medical tests, it seems to me that's going to swing the door wide open, anything goes, by way of proof of who cares about whom and at what time. I mean, he said that in October, he was trying to get away with her. He does not claim that in July he was trying to get away with her. He says he knew her a month before the sexual.
Okay, let me stop here. I suppose we can have some expert witness come in and testify to the etiquette involved in such relationships, if there is such, and what the custom and manner in the community is as far as how often these tests are run. They're done on a weekly basis or a monthly basis. I don't know, maybe we can get an expert testimony in that regard. But really, the probative value of this is nil at this point. It doesn't show anything, doesn't prove anything. So I'll sustain the objection. If it becomes relevant during testimony of Ms. Smith, then it could be revisited at that point. But those two documents relating to the test at this point don't really prove anything.
Would he be able to testify that he took measures to protect his wife, however? If the court is going to exclude these, I suppose...
Do you really want to go into the details of the sex activities and things of that nature? Is that really how you want to approach this?
Well, Your Honor, with respect to the sleeves, they've injected this into the case. We didn't inject this into the case.
Oh, sure, let the sleeves fly. What the heck?
That's what they would prefer. I would like to just handle it just with this exhibit and some short testimony, and let's get on to the real issues of the case. I mean, they would like this to be a sideshow with Lyle Smith.
Well, we can, I suppose what the people are trying to show is that he is a wonderful husband and father. We are more than happy, eager to litigate that issue. And then we can ask him if he had all the other women that he was having affairs with who were living in his home tested for AIDS. I suppose we can ask if he wore condoms. I mean, I think it's getting a little far afield.
I agree. There has to be some limit to the area of examination here, and we have so far refrained from getting into the specifics of such activity, and I don't see any reason to do that at this point. So the objection is sustained. I don't see any, it doesn't seem to be relevant, appropriate of any issue.
With respect to these two cases?
Yes. The other documents all seem to be relevant and can be used as ever you choose to use them. All right. Are we now ready to have the juries come in?
Yes.
All right. Let's have both jury panels come in, please.